Maternity leave, my lord,
For listing?
or listing, my lord.
Speak, you say to him, he'll do the needful.
My lord, in item 1 and 2, my lord, I have filed affidavit yesterday, my lord.
Hmm.
So that record may be called for. My lord senior is appearing.
Okay. Give the requisition
My lord, S2, my lord.
at 2?
Yes, ma'am.
Okay, at 2.
My lord, I'll
Yes, yes, give the requisition. Yes.
May it please your lordship, I beg to mention item number 69, lordship.
69.
69 hearing
Hmm.
22.
So many matters are
It
listed.
relates to promotion of assistant headmaster.
Huh.
But in this case, Karbi Anglong Autonomous Council filed an affidavit relates to promotion of headmaster, lordship. So
No,
for
what?
affidavit-
The respondent has filed affidavit.
I am appearing for respondent, private respondent, and Karbi Anglong Autonomous Council has filed an affidavit relates to promotion of headmaster. So
Hmm.
proper affidavit is required in this case, Lord.
So they have to file a proper affidavit.
Lordship, I am appearing for the KAC, Lordship. We'd like to file an additional affidavit, Lordship, clarifying this.
Okay. So they have filed the affidavit showing for promotion of headmaster.
Headmaster,
Acha, acha. But it should be assistant headmaster.
Lordship.
Okay. Heard Miss R. Deca, Learned Counsel for Respond number 7, and Miss
S. Kemprai, Lordship.
S. Kemprai, Learned Counsel for KAAC. Miss Kemprai submits that she will file an additional affidavit in the instant matter and has prayed for some time. Prayer is allowed. List this matter when?
3 weeks.
You are also there. Acha.
Maybe. Actually, this matter is already part heard. It's a conclusive stage.
Parted before which court?
This matter, which my learned mentioned.
Before this
It's
court?
fully heard
Before this court?
by other court.
So let it be listed there.
Yes, that may be listed.
But whether it is
Our
made
team
part
might
heard?
be a humble submission, that may be fixed. Otherwise, it's because it's a whole pending matter, promotion.
But then it's not made part heard, I'm told.
No, it's a part heard.
No.
And
Not reflected.
It's not
10,
recorded, Lordship.
10,
It's not
3,
recorded as part.
10/3/26, there is an order that hearing remain inconclusive.
No, but it should be.
Okay, prayer is up. Further, Mr. N.K. Mori, Learned Counsel for the petitioner submits that the matter has been heard at length by another court. Bracketer Diriba, Justice?
Justice Yogenia,
Justice?
Honorable Justice Yogenia.
You can.
Oh, Justice Nair. Justice UK Nair. And accordingly, prayer is made for listing of the said matter before the said bench. Registry to verify and list the same. List this matter on?
That may be fixed, ma'am.
List this matter on what date you suggest? You three of you? List this matter on 17th of June, Wednesday. 3 weeks, she said, so 17th of June.
Maybe pleases your ladyship. Your lordship, taking concern of the other side, your lordship, I beg to mention item 20 to 39. It's a tag matter, your lordship. Verification of records is going on. Some headmasters get their, your lordship, a post. So your lordship, while your lordship verifying the documents, some time, further time may be needed. So kindly, matter may
So
adjourn.
documents of the petitioners are being verified.
Yes, your lordship.
For what purpose?
The post of headmaster, your lordship. So
Achha.
your lordship, kindly grant us 3 weeks' time, your lordship, for
My lord,
verifying
it
the
may come on
documents.
8th of June, my lord.
Your lordship, let the 8th of
Learned Council, Learned Standing Council for Higher Education or Secondary?
secondary
For
education.
secondary education, Ms. P. Das submits that the verification of the documents documents of the candidates for the post for appointment to the post of headmaster is being carried on, and as such has prayed for some time. Prayer is allowed. List this matter when?
8th of
12th.
June, my lord.
8th of
8th of June, my lord.
8th of June.
12th June.
12th of June.
12th of.
Okay, 12th of June.
Connected one single case is was fixed on 8th.
That will take, your lordship.
When that
When the
matter comes
matter
up
has
on
come.
8th, you make the prayer.
Actually,
Yes,
cases
your
are
lordship.
covered, my lord. It can be disposed of today itself, my lord.
No, your
Yes,
lordship, documents of
because
verification is needed, your lordship.
they want to see all the files, my lord, verify what are the impugn orders in which cases, my lord. Only for that they are taking
Without
time. There's nothing-
verifying, recheck the
Issue
your
is-
lordship
issue is whether-
documents on record,
issue
your
is-
lordship,
issue
how
is
can
whether
it
NOC
promote it?
Whether NOC will be requirement for all these promotions.
So-
That's the issue. So it might 8th of my lord, 8th or if my land friend is insisting on 12, my lord.
12th.
12th Friday, my lord, it may count 11th, my lord. Then.
Mm.
11th.
11th. 11th is again a hearing
Yeah,
day.
on that
Okay.
date, it may disposed of, my lord.
11th of June.
I'm deeply obliged.
May please, your lordship. Item 68, my lord.
Item
Yes, ma'am.
68.
Yes, ma'am.
Yes.
Others for the consent here, my lord. I am petitioner, sir. Tally this matter may be listed after 1 week, my.
You are for the petitioner.
Yes, my lord.
I is there.
I opposite party. filed,
Okay.
ma'am.
So you want it to be on?
Yeah,
What date you want?
1 month, after 1 week, ma'am.
After 1 week. Miss
Is DJ Bora.
D.
J Bora.
Dev Bora, learned counsel for the petitioner.
Yes, ma'am.
Petitioner submits that the instant matter may be taken up after a week. Prayer is allowed. List this matter on 3rd of June. Or what?
5 June.
1st of June.
Yes, 5
1st
June.
of June.
Oblige me.
May I please, your lordship? Lordship, I beg to mention item number 9.
Hmm.
I have instruction to not to press this.
Not to press.
Yes.
Okay. Mr.
H.
No.
Rahman.
H. Rahman, learned counsel for the petitioner, submits that he has instructions to withdraw the matter. The prayer is allowed. Matter is closed as withdrawn.
May it please ladyship. Ladyship, I beg to mention item number 64 for upgrade.
64. At 2 o'clock, we will give a try.
Please, my lord. My lord, I beg to mention item number 42, lordship.
42.
Lordship, I am for the petition, respondent number 5 and 6, lordship.
Mm.
We have communicated with the petitioner in person, lordship, but he is supposed to present at the time of.
Petitioner in person, yes, okay.
lordship. He is supposed to present at the time of mentioning, lordship, but not here now, lordship.
It's okay, he is
Yeah,
petitioner.
we have to file objection in this IA. IA is ready. We
Huh.
send it for signing, lordship.
Oh, you will file your objection in the IA.
Lords.
Okay.
Lordship,
Third-
if you have an objection in this matter, the matter may not be mentioned in the mention hour.
Petitioner in person has to say something.
Yes, ma'am. My lord.
Huh?
Yes, my lord.
Okay, let the matter reach then.
Lordship, just we have to file this objection, fix it after 1 week or 2 weeks, as per your lordship convenience. Without signing, without filing objection, how can?
But if there is an objection, let the matter reach then. Right. You stay for some time.
Lordship.
Lordship, I beg to mention for listing on contempt.
Okay, speak to the court master, he'll do it.
25. May please your leadership. Leadership, with consent of the other side, I beg to mention item numbers 66 and 67 of
Mm.
today's daily list.
66 and 67, why?
Leadership, in item number 66, the instructions which we have received, they're not adequate, they're incomplete. So
Mr. Buragoy, you are there in the matters? So you are for the respondent?
yes, leadership,
So instructions are not complete?
they're not complete.
Yes, Mr. Buragoy, they are praying for time.
We have taken so many times, my lord. Your lordship will grant them time.
Well, as the last opportunity. Okay.
Huh.
So you are appearing for respond number?
For the health and family welfare, leadership.
Okay. Mr.
M. Bhuya, leadership.
M. Bhuya, learned counsel for, standing counsel for
No,
health,
no,
or learned counsel
None.
for, appearing on behalf of,
Mr. B. Gogoi, leadership.
appearing on behalf of Mr. D. Gogoi, learned standing counsel for health and family welfare, submits that the instruction in the said matter is not complete, and as such, they have prayed for time, and as such, he has prayed for time. Prayer is allowed. So prayed for time to get the full instructions. Prayer is allowed. Mr. A.C. Buragoy appears for the petitioner. List this matter when?
Leadership after 2 weeks.
List this matter on 15th of June.
Leadership. Leadership, in item number 67, there is an IA for which we have to file an objection also. Because
Okay. In item number 67, what likhiba? Mr. Rahman, learned counsel on behalf of Mr. D. Gogoi, B. Gogoi, submits that he has to file the affidavit in opposition to the IA filed by the petitioner,
yes,
to
leadership.
the interlocutory application filed by the petitioner. Prayer is allowed. List this matter on 15th of June.
Ladyship, it's M. Huya, Ladyship.
Oh, M. Bhuya, yes, Mr. Bhuya.
Much obliged, Ladyship.
Rehman bole bhul korlo.
May I please, your lordship? I beg to mention one writ petition for admission in, that matter was last listed.
For listing?
Yes, for listing.
Yes, you speak to the court master, he'll do it.
Much obliged.
Well, it's similar.
Same, if somebody has prayer for listing. Give your dates, we'll list it.
May I please, your lordship? With respect to item number 46, your lordship.
46, yes.
Lordship, in this matter, the higher education has filed an affidavit in opposition.
Mm.
And we want to file a reply.
File a
to that.
reply. Okay. Mr. R.A.
R.A. Mazumdar.
R.A. Mujumdar, learned counsel for the petitioner, prays that he may be allowed some time to file his reply to the affidavit in opposition filed by the respondent authorities. Prayer is allowed. List this matter on
3rd week of June, any date, your lordship.
3rd week of June.
Yes, your lordship. Or 2nd week.
List this matter on 10th of June.
Oblige.
Lordship, I beg to mention item number 45, Lordship. I am for respondent number 4. Lordship, we are directed to take steps on respondent number 3 and 5 also. Accordingly,
Respondent number 4 were directed to.
to serve notice, Lordship, to 3 and 5. Accordingly, we have done so. Now, Lordship will be filing our wakalatnama for them on behalf of 3 and 5.
So 3 and 5 also you are appearing.
They will be appearing for
They
3 and 5
will be
also.
appearing for 3 and 5. And we will also file our reply, Lordship. So we need 3 weeks time.
Okay, Mr.
K. Mujumdar.
K. Kolita. K.
On behalf of K. Kolita, I am K. Mujumdar.
Mr. K. Mojumdar, on behalf of Mr. K. Kolita, appearing for respondent number 4, submits that they will be appearing for respondent number 3 and 5 as well, and would file the wakalatnama within the course of the day.
No.
Would file the wakalatnama, full stop. Mr. A. Bhattacharjee,
DJ Kapil.
DJ Kapil, learned counsel for the petitioner, is present. As such, Tata DJ, he prays for some time. K. Kolita, prayer is allowed. List this matter on.
After 3 weeks, Lordship.
List this matter on 17th of June.
My lords. Hello.
Item 3.
1 and 2 adjourn only. Oh. Yes.
My lord, here, my lord, in this case, my lord, petitioner before your lordship is a first wife, my lord.
How
And,
many motions?
Her husband is, my
Okay,
lord,
motions are pisot kali patha to me. Yes, Mr. Burbarmia.
my lord, petitioner before your lordship is the, my lord, first wife of, my lord, her late husband, my lord. And
She is claiming pension.
pension, my lord. So, my lord, here the, my lord, respondent, who,
What does the pension rule say when there are 2 wives?
my lord, the first wife will receive, my lord, and she will maintain, my lord, second wife, my lord.
Acha. Any amendment to the pension rules?
No, my lord, my lord, there is a full bench judgment, my lord.
Oh, acha. If he does not agree, if he does not,
Pay, my lord, then she may approach to the appropriate forum, my lord,
the second wife.
second wife,
The requirement is that she will maintain the second wife
second wife.
from the money that she receives.
Yes. And department may also, my lord, in appropriate case may segregate, my lord.
Segregating is better. Right, 50-50. Okay, here,
My lord, here, my lord,
first wife did not get or what?
yes, my lord, she is respondent number 8, my lord. She is also otherwise, my lord, government employee,
Hmm.
as a, my lord, LP school teacher, my lord, second
Hmm.
one.
But she has not got pension due to her husband.
She will get, my.
No, what is the prayer here?
Yeah, here, my lord, the pension may be allowed in favor of, my lord, present petitioner before your lordship, my lord, and he will, my lord, give her, my lord, 50%, my lord.
My lord, this is not, this may go, madam, because private respondent is there.
Heard Mr. A.M. Burmia, learned counsel for the petitioner, and Ms. S. Chutia, learned standing counsel for higher education,
Elementary education.
elementary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a writ of mandamus directing the respondents to grant family pension slash compassionate family pension in favor of the petitioner being the first wife of her late husband. Full stop. She has also prayed that the authorities may deduct and deposit 50% share of the said pension in favor of respondent number 8 each month. Full stop. Huh. It is also prayed that respondents should issue next of kin certificate. This is what next of kin certificate she will apply before the authorities and get.
Not necessary.
This prayer is not required. It will not like a third too. Issue notice, returnable by 3 weeks. Petitioner to take steps for service of notice upon respondent number 8 by speed post with AD or by usual process. Miss Chutia appears for respondent number
1, 2, 5, 6, and 7, madam.
1, 2, 5, 6, and 7.
Madam.
1, 2, 5, 6, and 7. 3, Director of Pension. It's Miss S. Kumar, Learned Standing Counsel, appears for Government Advocate, appears for respondent number 3 and 4. List this matter on after 3 weeks, okay? On 17th of June.
Followed. Diploma.
Such a honest prayer, Mr. Bormia, such a good and an honest prayer. Give me and 50% deduct. Yes. Yes, Mr. Bora.
Yeah, please, your lordship, my lord, the issue involved in the writ petition is, my lord, loss of seniority of the petitioner when he was transferred from one district to another, my lord. That order at page 14, my lord, annexure 2, my lord. The clause 8, my lord. The teacher concerned shall not claim seniority over the existing staff of the newly posted school. On reporting in the school allotted by the district level committee of the newly posted district, the seniority of the teachers will be determined from the date of reporting in the school. My lord, this is in violation of the provisions of the rule, my lord, because the relevant rule 7.
7 of?
7 of the Assam Elementary and Secondary School Teachers within bracket Regulation of Posting and Transfer Act 2020. My lord.
What a long act. Acha, it is there in the manual?
Yes, my lord. That,
Page number?
Page 15, my lord.
So rule 7.
Page 15, Rule 7, my lord. Inter-district transfers norms of teachers. The government and the competent authorities shall be guided by the following norms in respect of inter-district transfer of teachers. A teacher working in a district continuously for 10 years or more can apply for transfer to his or her home district or to a nearest contiguous district. Then your lordship kindly come to next page, my lord, Rule 11.
Was it on his request?
Yes, my lord.
This
He applied for the, in terms of this provision, my lord, because he completed 10 years in Manila district, my lord. Then Rule 11 says, my lord, transfer of a teacher made under this act shall not in any way affect his original seniority in the respective cadre of the service.
So, in view of that, Ms. Das,
And
how
my
come
lord,
this 8 clause is included?
regarding this issue, my lord, this honorable court has passed one judgment, your lordship may go through it, my lord. Regarding the same issue.
That is fair. Otherwise, person will go after 10 years and his seniority will be counted from the date of joining,
Yes.
reporting.
Yes.
Hey, Hemenda. Judgment.
The petitioner joined initially in his post in the year 2000.
In the respective cadre of service, right?
Last paragraph of the judgment, your lordship.
Accordingly, clause 8 of the order stands set aside and course. Consequently, seniority of the petitioner will be governed by section 11. So, Ms. Das,
At this stage.
can
Your
it be
Lordship-
disposed of at the motion stage?
No, your lordship. At this stage, notice may go, your lordship.
Otherwise, your point is settled.
No, your lordship. Let the instruction may shout for your lordship. Let the notice may
if
go,
Yeah,
let,
if you notice, let her obtain instructions, my lord.
let the notice may issue, your lordship.
If not issue, probably she has not gone through the judgment, my lord.
Okay. You get the instruction. Why this clause 8? There also clause 8.
Same.
I mean, the same order they type out with,
Yes.
in respect of other persons also. Okay.
And in that case, my lord, the learned counsel for the education department has submitted that probably due to oversight that has caused. it.
Ah, yes, perhaps.
On inspection, he
But there will be no interim here. Let the
Yeah,
instructions be brought in.
Obtain inspection.
Okay, heard Mr. D.P. Bora, learned counsel for the petitioner, and Ms. P. Das, learned standing counsel for secondary education. By this application filed under 226 of the Constitution of India, the petitioner has prayed for setting aside of clause 8 of the order dated 27th of December 2023, by which it was ordered that seniority of the petitioner would be determined from the date of reporting in the school where he is transferred from his earlier school. Mr. Bora submits that the said clause is against the provisions against the law laid down in clause in subsection 11 of Assam Elementary and Secondary School Teachers within bracket Regulation of Posting and Transfer Act 2020, which provides that transfer of a teacher at his request or otherwise shall not in any way
After 10 years.
affect his both it will be
Yes,
included
Yes, my lord.
shall not in any way affect his original seniority in the respective cadre. Full stop. He has also placed a judgment of this court passed in writ petition 2646 of 2024, by which a similar clause 8 in respect of another employee was set aside and quashed, and the seniority was directed to be maintained as per section 11 of the said 2020 Act. Ms. P. Das, however, submits that she may be given some time to obtain her instructions. As regards the law point involved, that whether a transferred teacher would get his seniority as per his posting, as per his seniority in the original cadre, as per his seniority in the original in the respective cadre, or from the date of reporting to his new place. List this matter. It will not take long, Ms. Das. List this matter on 3rd of June.
Yes, my lord.
Today is 21st.
Yes, sir. Lordship.
3rd of June.
Obliged.
I'm deeply obliged.
Hmm. Yes, 5.
May I please, Your Lordship? We are tutors. Our
Mm.
original appointment was considered to be illegal or irregular.
Hmm.
Thereafter, the government of Assam took a policy decision.
ये दे दीजिए उनको. Mr. Bora, he has left. बाद में दे दीजिए. Yes, yes. So he was a tutor. You can take back your judgment.
And accommodate us as tutors. While accommodating my lordship,
Acha, you were appointed as a tutor, but they said it's an irregular, illegal.
Yes,
Thereafter,
ma'am.
government of Assam took a policy decision and they accommodate us as tutor. And
After that,
after
you were removed.
no, we were originally appointed as assistant teachers. ma'am.
Acha.
For some few years, we got salary. Thereafter, salary has been stopped, and the matter was considered with the government, and the government accommodated us as tutor. And while accommodating, we have been included under the purview of Provincialization Act, and we are receiving salary under the Assam Venture School Provincialization Act, which I have annexed, my lordship. And this honorable court also considered this matter whether pay parity, my lordship, equal pay for equal.
Oh, you are praying for pay parity.
Honorable court already considered which I have given my lordship.
Hmm.
Please see page para 179, my lordship. Para 179.
Acha, 1 second, just 1 second. Okay, Miss Borua, right? Miss
Fukan.
Huh?
Fukan.
Fukon. Miss Fukon, what? You'll bring instructions or what?
My lord, notice may be issued, my lord, we will take instruction, my lord.
Only that-
My lord, within the bank, my lord, between 1991 to 2001, some illegal appointment was there, my lord.
So
So all
2001,
All are falls within the illegal and irregular teachers, my lord. They were, after that, they were accommodated as a tutor, my lord. So they are claiming, my lord, for the upgradation of supernumerary postman. So that is why I may be allowed to take instruction and in this case, my lord.
page
27.
27.
27. Here, last para before the table, my lordship.
Hmm.
The fixed salary for the tutor is as per the Assam Education Provincialization of Service and Teachers and Reorganization of Education Institution Act 2007.
But it is fixed salary.
Yes, sir.
You are receiving fixed salary.
So, our claim is
Your
that-
services were not provincialized.
but our salary is being given under the purview of this act, my lordship, while accommodating this laws has been introduced.
You bring the instruction, how can that be done? It's a fixed salary. And then they were under the Provincialization Act 2017.
Yes.
That can be done or what?
No, my lord.
Some of the
My lord,
teachers were
provincial-
accommodated as teachers also, my lordship, because they were having DLED degree.
I said, let them bring instructions. Heard Mr. S.B. Laskar, right? Learned counsel for the petitioner and Miss
And Fukan,
Anne Fukon. Anne stands for?
Nagaland.
Acha. And Anne Fukon.
Yes, sir.
Learned standing counsel for?
Elementary.
For elementary education. By this application, the petitioner has prayed for upgradation
Yes, ma'am.
of their respective supernumerary post. Petitioners, supernumerary post of tutor
Ma'am.
of LP UP school to supernumerary post of teacher along with salary benefit pay scale at par with the post of assistant teacher of LP UP school. Full stop. The petitioners have also prayed for application of the existing revision of pay, taking into account the qualification of the petitioners. Issue notice, returnable by 3 weeks. What is this judgment you have placed?
Yes, yes.
Okay, we will consider during the time of hearing. Any private party?
No private.
Miss Fukon appears for all the respondents?
No, ma'am.
One, no, not one.
1, 2, 3, and 4.
Finances too, you
Yes,
can
ma'am.
appear.
5, 6, and 7, ma'am. 1, 3, 2, 7.
Acha, 1, 3 to 7.
Yes, ma'am.
And Mr. Choliha can appear for finance?
Yes, ma'am.
Mr. A. Choliha, learned standing counsel for finance department. Extra copies be served by the petitioner within a period of 2 days from today. List this matter on 19th of June. Yes, Mr. Mohanta?
May it please, Lord. In this case, Lord, much very simple, Lord. Advertisement was issued by the Mongol College for the post of botany, Lord.
For the post of
Botany, assistant professor, botany.
assistant professor, botany.
Interview was held for 11/24. From reliable source, I come to know that my name was forwarded for selection, along with other candidates. After some time, I appeared before the DSC. That's why the other candidate has joined, but my file was not, and my appointment was not given. Then DSC said that there is a complaint against me. Then I filed an application to consider this complaint along with my application and to further proceed with the file. Thereafter, DSC was pleased to hear the matter, and hearing took place on 23.
What took place?
Hearing in the DSC. With the principal, myself, hearing took place on 23/12/2025. But till date, no communication, no appointment has been given, neither.
When was the hearing held?
23/12/2025.
Oh.
So my simple prayer is let them produce instruction from what the
Other
result.
candidates were appointed.
That's it?
Other selected candidates appointed.
No. Yes, other subjects, Lord.
Other
The
subjects.
same advertisements, same interview. They were appointed earlier, 1 year ago. But my appointment is pending. I may not be appointed, Lordship, because, but what instruction, Lordship? Why my file is waiting?
Yes.
Actually,
Why is he left out? Okay, there was a complaint. But then there was a hearing also done.
And Lordship, I'll have to obtain instruction or either.
What is the fate of that hearing?
Yes, Lordship may dispose of this matter, directing the authorities to decide the Lordship hearing within 3 weeks, Lordship. Then we can
No, hearing was done. Maybe they have decided something.
complete it.
Being completed only.
So you just have to bring the instruction, the outcome.
Outcome, Lordship.
That has not been communicated to him.
Yes, Lordship.
Okay.
Whether
Heard,
completed or
Mr.
not, Lordship, that I'll have to.
That you would bring the instruction. Heard Mr. D. Mohanta, Learned Counsel for the petitioner, and Mr.
A.R. Tohbildar.
A.R. Tohbildar, Learned Standing Counsel for Higher Education. By this application, the petitioner has prayed for, prayed for a direction to the respondent authorities regarding the outcome of the hearing done on 23/12/2025. It is the case of the petitioner that the petitioner applied for the post of assistant professor in botany department in pursuance to an advertisement dated
12/7/24.
12/7/24. It is the petitioner thereafter came to know that he was selected, but was not appointed, and he later came to know that reason for his non-appointment is that a complaint is filed against him. He as such approached the DLC's district, no,
Director of Higher Education.
Director of Higher DHC.
DSC.
DHC, okay. Approached Director of Higher Education and submitted a representation
6/11/2025.
on 6/11/25, and the Director of Higher Education fixed a date for hearing, and the hearing is accordingly done, but the petitioner is unaware as to the outcome of the said hearing, since he was neither appointed nor he was apprised of the reason for his non-appointment. Issue notice to the respondents.
1, 2, 3.
Extra copies to be served within a period of 2 days from today. Mr. Tohbildar appears for respond number
1, 2, and 3, Lordship.
1, 2, and 3. Petitioner to take steps for service of notice upon respond number 4 by speed post or with speed post with AD or by usual process. List this matter on 19th of June.
Obliged.
Very pleased, Your Ladyship. In this case, the petitioners are working as lecturers.
Is 1 second. If for neither he was appointed nor he was apprised Apprised of the reason for his non-appointment till date will dia. Appoint korbo pare. Yes, Mr. Mohanto, right? Mm.
This case, the petitioners are working lecturers and they are praying for EDC scale.
Mm.
And this moment notice may be issued to the respondent
They have not been granted UGC scale.
as per the notification dated.
Why?
Worship will kindly favor the notification, which is at page annexure 7, page 92. We rely heavily on this notification of office memorandum.
Acha.
Annexure 7.
You are challenging
No,
challenging
we are
this.
relying on this memorandum.
Oh, acha, he is relying on this. So he is working, only one person, or they. They are working as
Lecturer,
lecturers in the same college,
different colleges. Of
in different colleges.
Now they've been termed as tutor assistant professors instead of assistant professors. The new term which has been given now is tutor assistant professors
Tutor assistant professor
under the new act.
under the new act.
So
And they are entitled for UGC scale.
I'm praying for them. That Alani signal.
Okay, both cost of, I think.
Yes.
Yes. Okay, so heard Mr.
KM.
K. Mohanto, learned counsel for the petitioners, and Mr. K. Gogoi, learned, what, you are standing counsel? Standing counsel of higher education? Standing counsel of, no, I have not seen you before. It's a learned standing counsel for higher education. It is, by this application, the petitioner has prayed for granting them the UGC scale, comma, they having appointed as tutor assistant professor in different colleges in the district. Issue notice, returnable by 3 weeks. Mr. K. Gogoi appears for 1
and 3.
3. 1 and 3. Finance, Mr. A. Choliha. Yes. Mr. You are for finance, right? Yes. Mr. A. Choliha, learned standing counsel for finance. Represents respond number 2. List this matter. You bring the instruction, otherwise it's a simple matter. Assistant professor not getting UGC scale.
They are not entitled, Lordship. I will bring it by way of affidavit, Lordship. Already this issue was decided by the Honorable Court, Lordship. Exactly that particular OM was relied by them. That was on that particular count, Lordship. Honorable Court has decided the issue, Lordship.
Acha.
They are not entitled. That particular OM is not backing by the any statutory provisions. Even Rule 24. I will explain everything, Lordship.
Mr. Gogoi, K. Gogoi also submits that he will file an affidavit by the next date fixed. List this matter on 19th or 17th? 19th of June. Extra copies, huh?
After summer vacation, first.
Mr. Mohanto, extra copies. Extra copies may furnished. Lydia. Okay. Okay.
On
So
15 July.
15 July. 15 July.
July.
That's
In the
long.
meantime, we'll file affidavit.
Mm.
We'll file affidavit.
But then it is too much. 24th of June.
No
Okay.
issue.
24th of June.
No issue.
After few days from June, let it go. Then we will fix it after July. Okay. So, the registry is directed to reflect the nomenclature of the finance department. What? SC finance department. Nomenclature, that is SC finance department in the cause list. Yes, Miss Meera is there. Yes, Mr. Yes, Mr. Datta.
Limited prayer, the petitioner is a nursing institute. They are having the capacity to intake 60 students, DNM courses.
So admit
Admit,
60 students.
60, Lordship will see that the annexure 2. Of course, it was written as 90 here, it will modify later on. But annexure 2, page 21.
21.
21.
Yes.
60 to 90, though it's mentioned, but it was by origin done at page 23. It was
Acha.
modified to,
For enhancement of seats from 60 to 90 seats.
it was a mistake, page 23 is the origin number,
Acha.
30 to 60.
23? 30 to 60. Enhancement of seats from 30 to 60. Okay.
Instead of 60 to 90. Now, they have prayed for enhancement to 100 in terms of annexure 4. Annexure 4, my lord. Serial number 3. My lord, if the parent hospital beds, my lord, has 300 my lord, beds, my lord, then they're entitled to 100 my lord, at least my lord,
No,
100.
why is serial number 3 important? What about the other serial numbers?
No, my lord, this is the criteria which where I fit in, my lord. That's why I'm asking.
Uh-huh.
This is the criteria where I fit in, my lord.
Where you fit in?
Yes, that's why, my lord, I'm placing that. My lord. So 300 seats, my lord, and my lord, 100 my lord, seats can be given if the parent hospital is 300 beds. Now, my lord,
300 beds?
if the parent
This is a nursing institute,
Not
right?
used, my lord, but it has to be, has to tie up with the blood hospital, my lord.
Ah.
That I have,
Mm.
and my lord, that hospital is 1300 beds. I'll come to that, my lord.
Mm,
So I fulfill that criteria, 300 beds,
mm.
and my lord, thereafter, my lord, I applied for my lord enhancement to 100 beds, my lord, page 27.
Page 27.
27.
Yes.
I make an application for enhancement.
Of seat capacity. Seat capacity means beds for the
No,
patients.
my lord, for my lord, admissions, my lord.
Training,
For
training.
training.
Of the nurses.
Nurses.
Oh, acha.
For that, they have to be have an attachment or a tie-up with the hospital, which has got some number of beds. So 300 bed is the minimum criteria for not having at least for 100 seats and for nurses.
300 beds in the hospital.
Hospital.
100 seat in this
Yes.
nursing institute.
Nursing.
100 nurses.
Nurses.
So earlier it was 60.
60, madam.
Now you are praying for enhancement to 100.
100. Now the director, my lord, of health services, my lord, page 28, submits a report.
Yes.
Last paragraph, last but one paragraph, my lord. Whereas it is requested the said proposal that as per the so-and-so notification dated 27/11/2024, which I just told, my lord.
Which is which notification?
That, my lord.
27/12.
Yes,
Okay, yes.
27. Institutions whose parent hospitals have bed strength of more than 300 eligible to increase their GNM seat capacity to 100 students. In this connection, it is also stated their parent hospital, SMCH Silchar, has a bed strength capacity exceeding 1300
So
beds.
1300. Where is 300 and where is 1300?
I fulfill that qualification. Then, my lord,
So any hospital having 300 beds are entitled to, for the nursing institute, to have 100
yes,
nurses.
if I have a tie-up with that hospital, my lord,
And
I
the
can.
hospital that you are tied up with
It-
has
SM
1300 beds.
So SMCH Silchar.
So 100 nurses are very required, will be, of
Then,
course, subject to what you say.
Then, my lord, the joint secretary, my lord, as the police department, my lord, to examine and scrutiny, my lord, page 29, my lord.
Okay. What has police got to do in this?
They have to make some verifications, my lord. And accordingly, my lord, page 30, my lord, they sought some information from us.
Wait, 1 second. Details from NOC.
NOC,
For starting.
though it says starting, my lord, it's actually not starting, it's an enhancement, my lord. So the word used here, my lord, is applications received from different institutions regarding requests to NOC for starting.
Where,
It's not
where?
starting exactly. It's, my lord, actually got to be, my lord, enhancement, my lord.
Enhancement.
Now, my lord, page 30, my lord, so the superintendent of police, my lord, Kachar, he writes to us, my lord, asking certain informations, my lord.
Yes.
And, my lord, on, my lord, 21/1/2026, my lord, we provide these informations, my lord.
22/1.
22/1, my lord, Connection 9. Now, my lord, our anxiety is, my lord, that the academic session for 2026-27, my lord, page 32, starts from 1st of August 2026. But, my lord, after this, my lord, communication which we submitted the documents, nothing has materialized or it has not progressed. We don't know any progress of the matter. My lord, since the session is coming, my lord, near, it's, my lord, on 1st of August, the session is to commence. So, my lord, hardly we have any time, my lord. So they have to decide whether they give us or not, my lord. It's for them to decide. That's it.
Can you tell it today?
My lord, regarding the parent hospital, my lord, kindly peruse this order, my lord. The petitioner has suppressed material fact before this honorable court, my lord. The parent hospital, they must have a MOU for clinical exposure with a government hospital. Last year, my lord, as per the MOU, they did not pay the stipulated fees to the Silchar Medical College Hospital. So if your lordship peruses this order, my lord, thereafter that the Silchar Medical College.
This can be taken up for disposal today?
No, my lord. They are not entitled for this enhancement. They have not paid that stipulated fees, which is required to be paid, my lord, in respect of the students who are pursuing the course presently. only because of the interim order passed by this honorable court, the present batch of students, because so that their career doesn't get affected, my lord. That's why, my lord, this court passed an interim order to continue the clinical exposure in SMCS for the present batch only. And right now, just before some time also, I have obtained the instruction. They have not cleared their dues till date, my lord. They are defaulter, my lord.
Clearing their dues is a separate thing,
No,
but
my-
then enhancement.
Because for clinical exposure, because what they are referring that they must have a MOU with a government hospital for clinical exposure. So last
That they have.
no, my lord, that has been cancelled, and last year the SMCS Silchar Medical College Hospital decided not to allow them to take the clinical exposure in the Silchar Medical Hospital due to
So you are tied up with Silchar Medical College
Yes, my lord.
Hospital.
That is
Because-
Acha, acha.
because of the default. Then they approached this honorable court. This honorable court passed an interim order in respect of that present batch only. And as of today, they are defaulter, my lord. So further batch, my lord, we are not allowing, my lord, because they have
That
not.
is a valid ground.
Yes, my lord.
You have not cleared the dues.
Your lordship may peruse that
I'm not
order.
aware of that.
Everything is clear, my lord.
I'm not aware of that, what's called unfinished.
That's why I am saying they have suppressed the fact, my
My
lord.
lord, therefore, my lord, my prayer would be, my lord, of course, I have to get the instructions.
This petition was for challenging the cancellation.
Yes, my lord.
And I have to take the, my lord, by.
3 lakhs per year they have to give, but
Yes,
they have
ma'am.
not given.
Yes.
₹27 lakh arrears,
Yes, my lord.
3
And-
lakhs paid.
And during the course of that petition, I produced the relevant chart, how much they have collected from the student,
Acha.
but they did not pay. On because of the clinical exposure, they collected the lakhs of rupees from the students, and they have not deposited to the concerned college.
Acha, what is clinical exposure?
Means, my lord, they have to take the theory classes in the institute for practical classes.
Oh, acha.
That is called clinical.
So that is clinical exposure.
my lord.
Acha, acha.
They collected
So
for
okay, you collect the you get the
My lord,
instructions.
because of suppression
cannot,
of fact, my lord, this petition is liable to be dismissed with cost, my lord. Because, my lord, they collected fees from the students.
So
but
you
they
get
did
the
not pay.
I have
instructions.
to get the instruction then, well, because then this is a very serious thing is my lord is saying. Well.
I'll mention this in the order. You get the instruction, file an affidavit additional.
Man. Because
Okay.
I'm not aware of what this order is, well, which-
Heard Mr. M. Datta, learned senior counsel, assisted by Mr. Hmm? J. K. Minhas.
Mira.
Oh, okay, well, learned counsel appearing for the petitioner. And Mr. D.P. Bora, learned standing counsel for health,
Yes, my lord.
and family welfare.
Health and family.
And Mr. Povitra Soikia for
5 and 6.
for Director General of Police representing respondent number
5 and 6.
5 and 6. And D.P. Bora is representing respondent number
1, 2, 3, and 4, my lord.
1, 2, 3, and 4, Didiva, huh? 5 and 6. So all are represented. By this application, the petitioner has prayed for a direction to the respondent authorities, particularly respondent number 1 and 2, to consider and grant enhancement of students, enhancement of admission of students for training in the petitioner's institution. Petitioner's institution, that is Assam Institute of Nursing, from 60 seats to 100 seats. Stated to be in accordance with the revised norms and guidelines issued by the Indian Nursing Council for the academic session 26 to 27. The case of the petitioner is that earlier the students admitted for training were 60 in numbers, and it is provided under the rules, it is provided under the, it is a provided requirement that if the, what do you say, that hospital, connected hospital, parent hospital has 300 beds, then the capacity of the students in the nursing institute, capacity of admission of students in the nursing institute would be 100. And it is stated that the parent hospital, that is Silchar Medical College and Hospital, has more than 1300 beds. And as such, the petitioner states that the institute is entitled to admit 300 students for training.
100.
100 students for training. And as such, a prayer is made for increase of students from 60 to 100. Hope my votes are okay, right? General votes. 60 to 100. In pursuance and as such, the petitioner had made a request to the Director of Health Services for such enhancement. And the Director of Health Services, by a communication to the Additional Director General of Police,
No, madam, Joint Secretary
or to the Joint Secretary,
Health and Family.
yes, Health and Family Welfare, requested intimated that the petitioner institution has prayed for increase of the seat capacity to 100. And in turn, the Joint Secretary to the Government of Assam had asked for certain instructions from the Additional Director General of Police, SB, who had given the details. Oh no, who had asked the petitioner institution about certain information, which was again furnished by the petitioner association to the institution to the Deputy Superintendent of Police by letter dated 22/1/2026. Full stop. The learned counsel for the petitioner therefore submits that the academic session would start from 1st of August 2026 and till date, no communication has been given to them with effect to the increase in the student capacity. And as such, finding no alternative, has filed this petition. Mr. D.P. Bora, learned counsel for the Health Department, submits that the petitioner has not stated the complete facts regarding the case. Shall I say it? No, not required. No, you will file additional, no?
No, he has
Had not
suppressed material
stated.
Because my submission is that, my lord, the petitioner has suppressed material fact.
That I am not saying. It is too much, so it's okay. But Kikolo stated the entire facts. He states that the petitioner institution has not cleared the entire dues to the parent hospital, that is Silchar Medical College Hospital, and that the parent hospital had decided not to allow the trainee students to continue their training, against which the petitioner institution has filed another writ petition. That was by institute, right?
Yes, my lord.
Yes,
Same institute.
Assam Institute of Nursing.
Same,
This is
same, my lord.
same.
institute.
And in that case, it is, no, in that case, and during that said case, 3 lakhs of rupees was paid as an interim measure, and that it was admitted that Petitioner Association has to pay rupees 27,60,000 to the parent hospital. However, for the benefit of the benefit of the students who were continuing their training in the said institute, an interim order was passed not to disturb their training. As such, he submits that the question of enhancing the seats from 60 to 100 does not arise in the case. However, he further submits that he will get the instruction and file the affidavit, or no, you will not file, right? Nalage. In view of the said submission, Mr. Datta, Learned Senior Counsel, submits that he will get the full instruction and would file an additional affidavit if required. List this matter,
That this matter may be taken up along with that matter, because both are connected, my lord. Issue is connected.
That also can be done, Mr. Datta.
WBC 141.
He wants both the matters to be taken up together.
14152.
That, I think that the council is different. Who is the council? Council is different. So,
Different, okay. But then there they have challenged the decision of the parent hospital to discontinue.
Yes.
And here, enhancement.
If that is discontinued, how they can
That's
claim
fine.
for
No,
a
they could have
The
rejected.
present student goes, so what about new students?
Yes, my lord.
Otherwise,
So it may be taken up.
our prayer was below that they were not considering or they were not giving any decision, either rejecting or accepting. So that prayer, they will not, the director has said that we have an arrangement that.
Let it be taken up separately.
Separate.
It's okay.
My lord, in this case, the maintainability question may remain. open
That you
ended.
can always take up.
But otherwise, my lord, because on the next date, when I will place the facts of that writ petition, again, that has to be relied on, my lord. So it may, if it is taken up together, my lord, that is.
Let it be together then.
Yes, my lord.
Mr. D.P. Bora, Learned Counsel, further submits that the said writ petition which finds mentions aforesaid may also be tagged along with the said instant writ petition. And the number of the said writ petition is
1415.
writ petition number 1415 of 2025. Prayer is allowed. Let both the matters be listed together. When was that matter fixed?
That is not fixed, my lord.
4 weeks.
Yes.
List both the matters together. Let both the matters be listed together on 24th of June.
Yes.
Will it be too late? It's too late, I think. 17th of June.
Yes, my lord.
17th of June. Mr. Chaudhary, yes, I was about to call you and then your matter is also called. Yes, Mr. Chaudhary.
My lord, this is that homeopathic students matter, my lord, where the students have been sought to meet some.
Acha, this, I heard something.
Yes, my lord, your lordship has heard the matter before.
Necessary instructions by Mr. Buddha Gogoi.
Was supposed to obtain instruction.
B. Gogoi is not there. Miss Kumar, B. Gogoi, or Mr. Choliha, or after some time. But Mr. Acha. But he was supposed to get instructions. It's not fair on our part to keep Mr. Chaudhary sitting. Acha, okay. Acha, what is, or you will sit for some time.
We'll wait, my lord.
Or you can, proceeding with the case will again what inform? You go. What was that matter about? I forgot. Homeopathic.
These 5 petitioners, they are the students of Homeopathy College. And they have, my lord, passed the 4th year examinations. After the 4th year examination, they have to go for internship.
Acha, yes, I remember.
They are continuing. Then all of a sudden.
That 4th examination was set aside, was done away with.
Was cancelled without any notice to them.
Oh, that period, intervening period should be 6 months.
6 months. And, it is short by 15 days.
15 days.
And no fault can be attributed to the petitioners because, my lord, the councils there is a, my lord, mandatory provision where, my lord, the examinations are to be held in a particular time. And the results are also to be declared within the particular time. For instance, my lord, from the date of admission, the fourth year examination has to happen within 54 months.
4 days,
54 months.
54
From
months.
First year admission to the fourth year examination. So instead of
From first year to fourth year, there should be 54 months gap.
54 months.
And they can distribute the way they like, or what?
No, no, my lord. For every exam, there is a time. And that time has, my lord, exceeded by 10 months. So this is their fault, my lord. So from the, my lord, the documents I have annexed that they could not hold the examination as per the mandate of the council. And eventually, my lord, we passed the third year, and the gap between the third year and fourth year, my lord, there is a 15 days gap.
15 days short.
Short, my lord. And because
It should be 6 months.
should be 6 months. Because, my lord, there is a supplementary examination also, my lord. Some students fail in one subject, they can appear in the second, my lord, supplementary exam. And thereafter, my learned friend has come. Then, my lord, the impugn order, the instruction of which, my lord, my learned friend asked for time. If your lordship comes to the impugn order, it is 131.
And there is some power of condoning.
Yes, my lord, there is a power of revocation in the council's rule.
Yes,
Now,
131.
Comes to page 131. May I read? That is a small, my lord, letter. Pursuant to necessary opinion. In pursuance of the necessary opinion of the National Commission for Homeopathy, NCH, write letter number such and such, dated 29/1/2026, the students of fourth year BHMS of SJN Homeopathy Medical College, Gauhati, who had appeared in the fourth BHMS regular examination held in April 2025, without completing the mandatory minimum gap of 6 months between the examinations of third BHMS and fourth BHMS, the university declares the fourth BHMS examination held in April 2005 as null and void for those students who have not completed the mandatory gap. Now, my lord, my learned friend's submission was that there is an opinion from the, my lord, National Commission that referred to the first, my lord, first sentence. And, my lord, whether this was approved by them or not, my lord, that is the instruction my learned friend was.
Approve means the opinion.
Opinion, my lord.
On the basis of that opinion, the university has done this.
Yes.
Acha. So, Mr.
And
Bugo, you have...
thereafter, my lord, another order at is 140. Because, my lord, after that order, we negotiated with them, we wanted to know. So we
You are the students, right?
Well, the students, my lord, this impugn order is of 24th of February. But then, my lord, in the meantime, there were representations, there were, my lord, discussions. Then finally, my lord, page 140, this order was passed by which, if your lordship skip to the first two paragraphs and come to the third one, at page 140, on the aforesaid matter, an urgent general meeting of the teaching faculties and medical officers held on 6 May 2026 at 2 p.m. in the office of the principal, unanimously decided to withdraw and hold the internship, I'm sorry, my lord, internship training of the following list of intern doctors. So that has also been, my lord,
Challenge.
internship has also been, my lord, suspended.
They,
And that's why, my lord, immediately we came between.
and there will be again re-examination. According to them, they will have to reappear in fourth semester after completion of the 6 months and all that, right? The university,
The fourth year, then, my lord, they'll start again.
again internship.
Again.
They have passed fourth year.
Yes, my lord, that will, they will lose, my lord, considerable time in their academic career.
So, Mr. Gogoi, you have instructions?
Yes, madam.
In fact, my lord, they have also notified the examination on 15th of May, last February.
Fourth semester again,
Yes, my lord.
fourth year.
Now they have, my lord, most of these, they have completed how many months of
Internship.
For two petitioners, 2 months left. For rest.
For two of the petitioners, they have got only 2 months left to complete the, my lord, internship. And for the rest, my lord, 4 months. So they are 6 months. No?
Out of 6 months.
Yes.
Internship is for a total period of 6 months.
No, internship is
1 year.
1 year. Out of that, my lord, 6 months, all of them have completed, and my lord, 2 have completed, my lord,
10 months. And the rest have completed?
6 months.
6 months
And
or more than that?
6 months.
6 months. 6 months left.
For, my lord, 6 months left. For 2 petitioners, only 2 months left.
And they have fixed a date for examination
Yes.
for the
now
fourth
they have
year,
notified.
where these petitioners will have to again appear.
Well, this
Yes,
is my infraction.
this is like injustice to the students.
Well, lordship may go through my infraction and lordship will pass for this.
Yes. What is this instruction? You can also say.
So, my lord, in this regard, direction was made for conducting an inquiry. Thereafter, my lord, we intimated the homeopathy council.
Huh.
They said that yes, you can go for re-examination.
Re-examination.
Rest I leave it to your lordship.
15 days only short.
Yes,
of
my lord,
6
in the
months.
chart, lordship will see, my lord, the petitioners, they have, the gap is about 5 months, 16 days, 15 days, hardly, as my senior said, 15 days or 16 days,
Hmm.
period is left.
So that can be
That-
condoned. Any provision for condoning?
Yes, my lord, that your lordship will find at page 99.
A page
99.
19.
What? No, 99.
99. Okay.
Clause 14, Roman 3.
99. Oh, that you have shown, yes. When any university or medical, which, why there are 3 clauses, 3 clauses given twice. Mistake, I think.
No, that is a part of, my lord, the conduct of examination. But
Huh.
then, my lord, they have, my lord, framed it in that manner.
Where any university medical which grants medical qualification is satisfied, medical institution, this is MCI guidelines or what?
No, no, no.
This is
Council
Yes,
guideline.
homeopathy, National Council of Homeopathy.
That's
homeopathy, no?
exactly, my lord,
Central Council of Homeopathy, page 31.
Page 31.
Yes,
when
ma'am.
it starts.
Acha,
that,
huh.
give the-
Central Council for Homeopathy, okay. Where any university or medical institution in India which grants medical qualifications satisfy violation of any of these regulation causes undue hardship in any particular case, as the case may be made by order for reasons recorded in writing, dispense or relax the requirement in such an extent and subject to such exceptions and conditions as it may consider necessary for dealing with the case in a just and equitable manner. For dealing with the case in a just and equitable manner, sir, this is this little injustice to the provided that no such order shall be made except with the concurrence of the Central Council. So, an order for considering of exercising the power to relax will do.
My lord, in fact, my lord, whether they have considered the provisions of the, my lord, the regulation, that is the first thing, my lord. Because, my
No,
lord,
if I order that they will consider as per regulation 14.3
Yes.
And they would consider taking back that schedule and allowing the students to continue will do. Consideration order will do.
Yes, ma'am.
That will do.
Yes, because, my lord, your worship may not be, at this stage, at least, my lord, without their activity, your worship may not,
Yes.
my lord, allow, but that will be allowing the repetition. That cannot be done.
No, that can be disposed of today.
With consideration, your worship may.
With consideration, I'll dispose it of.
In the meantime, the, my lord, that, they'll continue as the interns, my internship.
They will continue.
I think, my lord,
But
because-
an order for consideration will go.
Well, that part regarding disposal, my lord, today itself. Lordship, let me have the instruction on that point, my lord, till that some protection will be given.
But when is the exam? 15.5
in June, my,
in June, coming June, see?
in June, but they have not given the date, my.
In the month of June. And name of the student includes your petitioner's
Yes,
name.
my lord. There are altogether 9 persons, my lord. The petitioners are at serial number 1. 4, 5, 7, and
And one is left off.
and
6,
6, okay.
9, 7.
So what to do? You will file an affidavit or what?
My lord, on the point of relaxation part, my lord, whether they are going to exercise this, or lordship may in the interim, my lord, grant us that liberty that we can in the meantime move for, my lord, relaxation. If that is done with the consent of the council, then probably entire issue will be sorted out.
Like finishing the entire matter.
Now, in the interim that we can do, my lord.
In the interim, what? They will consider the
Yes.
rule so and so.
Yes, my lord, that can be done.
Your lordship may say pendency shall not be a bar.
Shall
for
not
them
be a
to
bar, my
consider.
lord, yes. To initiate a process for relaxation. There is a provision which probably we have.
They should have already started the process of by fixing the month of examination.
My lord.
They have proceeded.
Hmm.
Now at this juncture,
Then lordship may take away two, my lord, I will have the instruction on this point. Whether
Huh.
liberty is granted, whether they would like to proceed or not. Otherwise, my lord, it will be, have to be decided on merit.
Because, my lord, not
There are two
only-
in that case.
It's not only relaxation, my lord, whether they have also fulfilled the mandatory requirement of the.
oh, it is their fault, not the students' fault. Why should they suffer?
Lordship.
So, okay, at 2, we can
At
pick it
2, my
up.
lord, I-
Let him get the full instruction. We can dispose of the matter instead of keeping it pending.
Lordship. Lordship will keep the instruction in record, my lord, I will.
At 2 o'clock. We need not pass any order. At 2 o'clock we will.
I will also like to have the instruction if I run it from the.
Instruction
Then
is
I
with
will
me.
give a my lord, xerox copy to them, my lord. I will have a photocopy.
Achha, okay. Take this, bring it back at 2.
Yes.
Of like.
এইটো এই দুটা তেওঁলোকক দি দিয়া MK চৌধুৰীক এটা আৰু হেৰিক। Yesterday's matter, right? Yes. Then you can attend family function. We'll finish up.
Much okay.
So you are referring to your AO, Mr. Biswas.
My lord, according to the affidavit and opposition
Uh-huh.
filed by the respondent number 7, us, just to show that there are other candidates who are much junior to them, because they are only contention in the writ petition. It's not about bias, malice.
Wait, let
Or
me
any-
remember what was that issue in this.
They want the entire selection process to be cancelled, entire
is it?
selection list of Udalguri district.
Mhm.
And whereas they have not added,
Where the criteria was wrongly followed.
yes, they are saying there is a violation of rule 14 of the, my lord, rule.
Because their seniority and 3 years experience, 3 years ACR.
ACR has to be
ACR.
considered and
Corrected lordship, I'm not challenging the entire select list. Perhaps my friend is of the wrong interpretation. I'm not challenging the entire select list. My prayer is, so far the respondent number 7 is concerned, who is junior to me, and I should be considered. That is my prayer.
there is no prayer in the writ petition what the learned friend is submitting. Yesterday also, my lord, same submission was made before this honorable court. I have read the prayer before this honorable court at page 13, my lord. Let us read the prayer once again. My lord, what the learned counsel is submitting is contrary to the, my lord, pleadings and the prayer made in the writ petition. If I may take your lordship to page 13.
Yes.
In the premises aforesaid, your lordships
Oh,
may be
take
pleased
out
to
page.
admit this petition, call for the record, issue rule upon the respondents to show cause as to why writ in the nature of statutory shall not be issued, quashing and setting aside the impugn select list dated 12/3/2024, issued by the
So-
Secretary, Board and Territorial Council, and the order dated so-and-so issued by the Director of Education, BTC, Kokrajhar, promoting the respondent number 7. Well, he is challenging the select list, well, the dated, by this date, the entire select list was published in the district of Udalguri, Baksa, Kokrajhar. Now, he is now, my lord, refining his argument and modifying his pleading in a way that he is attacking the selection of the respondent number 7 to a particular school, which also he cannot, because the select list is not pertaining to a particular school. The select list is published district-wise, and the seniority list was published district-wise. There are other junior members, junior cadre, junior colleagues who are standing in the select list who has been selected. He is not challenging those selection. He is challenging.
You have challenged respondent number 7's selection. But what about you? How are you aggrieved? Only that 7. And in
I
place of 7, somebody else can also get.
Senior to respondent number 7.
And if 7 goes, then you will be entitled or somebody else also could have been entitled.
No, I will be entitled in place of 7. Because I am senior to respondent number 7.
Acha, he's senior to you.
It is his presumption. On the basis of assumption and presumption, a writ petition cannot be filed. First of all, he is challenging the select list. My preliminary objection, the other affected candidates are not being added as a party respondent before this honorable court. What if your lordship decides in favor of the writ petitioner and cancel the entire select list? Because it is his prayer. Where the other parties would go, my lord, they will be deprived from a fair hearing. On this count only, my lord, this writ petition has to be dismissed. Moreover, his only contention is that he is senior to respondent number 7. This this doesn't make out a case in favor of him, my lord. There are other candidates who have been selected in the district of Udalguri who are junior to him. He is not challenging their selections because this is not a intra-school selection procedure. It is a intra-district selection.
Now
procedure.
that I have understood, but if respondent number 7 goes, then he will be considered for selection.
No, then my lord,
There, of course, that again depends on ACRs.
my lord, the ACR, he is only challenged to the selection of the respondent number 7 is that he is senior. But as per the rule, my lord, rule 14, the ACR has to be seen, interview has to be conducted, and particular procedure has to be followed so as to ascertain whether this person deserves the post of headmaster or not. It is not only the seniority, it is overall performance of the candidate. Of course, my lord, the institution doesn't want a person to be heading the institution who doesn't have the requisite expertise or the experience in the institution or whose performance throughout the year, 3 years is bad. And that's why, my lord,
So why is the interview held to see
but as
the
per the,
ACRs?
yes, my lord, as per the rule says the interview has to be conducted.
That I have seen. Interview has to be conducted only to see the ACRs.
ACR and overall interaction, how he is doing, my lord.
That is not a requirement otherwise.
This is not the requirement, but the overall interview, when an interview is conducted in a common manner, my lord, when an interview is conducted, something has to be ascertained. If only his seniority has to be seen, there would be no question of holding an interview. The purpose of holding an interview is to ascertain his merit.
Even for the purpose of checking the ACRs.
Yes.
Interview is not required.
Interview not.
They as a panelists will sit.
Yes.
They will decide.
So the question of this provision would not have been codified here in the rule had there been no question of apprising or ascertaining his merit or his quality.
But the process that is by which it is conducted is also not correct. Because assigning of marks was not provided for.
But my lord, the Supreme Court says, my lord, this selection committee has its own minor criteria to come to a conclusion who is meritorious and who is not, who would be preferred to whom, my lord. Well, the procedure adopted as per the rule is to ascertain the fit person to head the institution. Had the question, my lord, if only the ACRs to be seen, then the question of this interview and the selection committee would not have arisen.
That is what is in my mind.
Yes.
So, what is the purpose for holding the
Legislative
interview?
intent to this means to formulate this provision is to ascertain the overall merit of the candidate.
So, do you have anything to bank on?
Yes, my lord.
What?
I have.
You have decisions.
I have decision.
Because otherwise, the provision only provides that interview has to be held.
Interview has to be held.
14, which page number you are saying? Rule 14 or section 14, whatever?
Rule 14, my lord. Page 35.
Of this book. Yes, rule 14.
Rule, sub-rule 3. 3.
1 provides that ACR and the seniority, right?
If I may read the whole provision, my lord. The post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidates among the graduate teachers as per district-wise seniority list on the recommendation of the district selection committee constituted under Rule 16(2). The selection of headmaster and superintendent shall be based upon seniority and satisfactory annual confidential report for last 3 consecutive years. It is not only the seniority.
As per procedure provided under rule sub-rule 3.
3. But the 3 here, my lord, next page.
Where is 3? Oh, yes, 3.
Next page, my lord. Roman 3, my lord. The district selection.
No, one thing I just wanted to be clear that there will be a district-wise seniority list, right?
Yes.
On the recommendation of the district selection committee. Here also a district-wise seniority list is published.
Yes, my lord.
On the recommendation of the DSC.
Yes.
Right, constituted under 16(2). Okay. So, as per procedure provided under sub-rule 3. So, see sub-rule 3.
Sub-rule 3 says the district selection committee shall hold interview category-wise.
No, 3(1) before the end of
Before
shall make
the
an
end of the
assessment.
year, the inspector of school shall make an assessment of the number of vacancies to be occurred in the cadres of headmaster, superintendent, and to be filled up by promotion in the next year.
This is in respect of the entire district or what?
Entire district, my lord.
Inspector of school is one inspector for one
inspector in a
district.
particular district.
Okay, then
The inspector of schools shall call particulars in the prescribed format of the eligible candidates, teachers for filling up the vacancies through promotion. The member secretary shall hold the process of the application and submit them to the district selection committee. The district selection committee shall hold interview category wise and prepare a panel of select list double the number of vacancies of the concerned district, my lord.
Shall hold an interview category wise. Category wise is subject wise, category wise.
If the promotion is for the headmaster.
Acha, or superintendent.
Yes, my lord.
Wise and select, prepare a panel of select list, double the number of vacancies.
Well, if the vacancy is 50, then the total number will be
Yes.
100.
The select list so prepared by the DSC shall be submitted to the state selection board. State selection board after necessary verification, where a district-wise select list equal to the number of vacancies and publish the same in the office board. Board in such a considered demand after publication of the required. Okay, so.
My lord, even if assuming, my lord, he has a good case on merit, my lord, he is not entitled to challenge the entire select list, my lord. Though in the submission he has modified his prayer, which is not permitted. And in the pleading also, his only contention before this honorable court is the violation of Rule 14. What is the violation? He has not clarified. He is only challenging the appointment and the selection of the respondent number 7 on the basis of his seniority. Well, seniority is not the sole criteria. There are other factors to be considered. And the process he cannot challenge. He has participated in the selection process. Once he has participated, the Supreme Court is very clear. Once he has participated in the selection process, he cannot afterwards challenge the process unless he shows that this selection process is, my lord, affected or actuated by malice, fraud, arbitrary, or violation of some, my lord, rule. Say for example, the constitution of committee is not proper. The member sitting in the committee doesn't have the required qualification to head the, my lord, selection committee. He can challenge those. But once he has participated in the selection process, he cannot challenge the, my lord, process and the my lord, marks awarded against the individual, my lord, candidates. And more so when he cannot.
Show me the select list again of Udalguri.
But unfortunately, he has not even annexed the select list of Udalguri. He has annexed the select list of Kokrajhar.
Udalguri is there at page 47, I think.
Yes, 47 is the select list.
Yesterday I have handed over to Lordship this entire select list.
Achha, where is that page number?
Page 47, my lord.
This is entire select list only?
Yes.
This is in the, my lord, affidavit and.
Affidavit it's also there.
Oh, yes, yes. This is an affidavit.
Not in the
only.
writ petition.
Acha, so here, where are you?
My name is, my lord, at serial number 17.
Serial number 17.
17.
Tapeshwari Borya. And where is the petitioner?
But he has not been selected here.
Oh, achha, he has not.
His name was appearing in the gradation list where he was shown to be senior to the respondent number 7. My lord, what I was on, my lord, the serial number 17 is Tapeshwari Borya. He was appointed in the year 2010 and joined about 5 days later than him.
Yes, that I have seen yesterday.
There are other candidates. The serial number.
But you see here, this is a select list.
Select list.
In section 14, rule 14 contemplates of a seniority list, right?
Seniority list.
On the recommendation of the district selection committee.
Yes.
As per district-wise seniority list.
Yes, my lord.
So where is the seniority list?
Seniority list, your lordship will find in the affidavit filed by the BTC.
I think he has given yesterday the list.
Page 72.
Seniority list you have given, right?
In the writ petition, page 22 onwards, with relevant is 23.
And the one that you had given is select list.
No.
This one, yesterday?
This is a select list.
This is a select list.
Yes.
Same as that of the one that I have seen in his
Yes,
affidavit.
yes, same.
Acha, where she does not figure.
Petitioner name is not there.
Where is the seniority list?
Seniority list, annexure E to the writ petition, page 22.
Page 20. 22.
Yes,
Okay. This is the seniority list
seniority list.
made in pursuance to, made in conformance
72.
with Rule 14. This is
So it's a
provisional.
gradation list, a district-wise gradation list. Lordship will file provisional gradation list of assistant teachers.
Wait
by
one
school.
second. As
Other-
per district-wise seniority list. So
Same.
same, okay. So district-wise seniority list is, where are you?
I am on the page 23, serial
Hmm.
number 46 is the petitioner and 47 is the private respondent number 7.
So this is the gradation list.
Lordship.
And it is made by the, made on the recommendation of DSC.
No,
No?
it's a regular gradation list, Lordship.
But see, the Rule 14, again, it doesn't talk of select list. It talks of seniority list.
Well,
Ah.
seniority list, your lordship will find at page 72 of the BTC affidavit.
72
72.
of BTC
The
affidavit.
document my learned friend is referring to, my lord, it's a provisional, my lord, gradation list.
That will not clinch the issue.
72, 73 is the relevant, my lord, names, Runumi Priya Devi and Tapashri Boro.
73.
73, serial number.
This is
50.
the final gradation
Yes,
list of
ma'am.
assistant
It
teacher.
is as per the notification, my lord,
Acha.
issued from the office of the inspector of schools.
Under Inspector Udalguri District Circle.
Yes,
So this is the final gradation list, means it can be considered as
Yes.
the final select.
yes, select.
Seniority.
Seniority list.
So where is you and the
My
respondent?
lord, serial number 50 is the petitioner.
50.
Yes, 50.
50 is the petitioner.
And-
You know.
Right below, my lord,
51
51
is
is
you.
respondent number 7.
So, see, post of headmaster of a high school and superintendent shall be filled up by promotion from the candidates amongst the graduate teachers as per the district-wise seniority list. So, it has to be done as per this list. District-wise seniority list on the recommendation of DSC. The selection of headmaster shall be based upon seniority and then selection.
ACRs,
Then selection. First talks about seniority list.
seniority.
Then selection will be based on seniority and satisfactory. Not even best. Satisfactory ACRs, right, for the last 3 years. Provided that seniority of the graduate shall be determined on the date of Acha. Then this 3 talks of shall hold interview and prepare a panel of select list double the number. Hold an interview category wise. Okay. So selection based on seniority. So admittedly in the seniority list, he's senior, right?
There's no dispute.
Uh-huh.
I'm not denying.
Yes, he's senior. She is senior. And then if she has satisfactory ACRs, then she has to be appointed according to clause 1,
Yes.
rule, sub-rule 1. 3 says that there will be an interview. An interview, and that they will give double the number. Prepare a select list. Then after interview was held, after that they prepared a select list,
Yes,
right? Where she does not figure. It can be one ground that she doesn't have satisfactory ACRs.
Yes, my lord, probably, my lord. And that also, my lord.
But that is not the ground. But the interview board has assigned marks to each of them.
Yes, my lord. My lord, the Supreme Court has said in one of the judgments, my lord, I will read, my lord, later a little bit. In the interview, the selection committee has to, my lord, set out some standard of, my lord, scrutinizing or, my lord, finding out the best out of the lot, my lord. So who is best and who is having the best
But in
performance?
that case, I don't think so. The criteria for promotion is seniority and 3 years ACRs.
3 years ACR's purpose is, my lord, to see his performance during those 3 years.
Yes.
And performance, my lord, is backed by his, my lord, overall, my lord, conduct in the school, his service and the services he has rendered in the school, my lord.
That will be reflected in the ACRs.
ACRs, my lord, ACRs is, my lord, it is not to be, my lord, it is not his case that he has a good ACR and his case was not considered. His only case is he is senior. But if it is only his case that he is senior, there are other junior members who has been selected. It is not a, my lord, school-wise selection procedure.
No, we are not concerned with other juniors who will be appointed as headmaster in some other school.
No, they have already been appointed. They have already been selected. They are junior to the respondent number 7 and the petitioner. Based upon their
But
performance.
the schools are different.
Well, it is not for the school, it is for the entire district. Well, where the person will be appointed is for the authority to be, well, decide. Well, why he is after me? Because he is from the same school as I am. That's why he is thinking that he should be promoted to the post of headmaster. He has.
School does not matter.
School does not matter. Well, he is misconceived, my lord, while making the, my lord, pleadings in the writ petition, thinking that he has to challenge the selection of the respondent number 7 because only because she belongs to the same school.
That of course is a good ground because district-wise seniority list is there.
Yes.
And then few of your juniors were appointed. That you are not challenging. Only in respect of respondent number 7 because you two belong to the same school. But we are at dark why her name is not there in the select list. Whether her ACRs are bad, but other consideration they cannot have. I mean, 3 will not eat up sub-rule 1.
But this rule has to be read, my lord, has to be read, my lord, conjointly.
Conjointly.
One ACR is
But you see here, 14 it says, as per procedure under the sub-rule 3. So that is a procedure. Sub-rule 3 is the procedure. But sub-rule 1 is the substantive law. This has to be considered.
This has to be considered, my lord. But
so they cannot consider something else.
my lord, this one has to be considered not in isolation of rule 3. Well, rule 3 says, my lord, there has to be an interview to be conducted by the selection committee. Well, when an interview is conducted or when an interview is held, my lord, what would be the criteria to be seen? This criteria to be decided by the selection committee. He is not challenging the, my lord, qualification of the selection committee. No, they cannot, my lord, scrutinize or they cannot hold the, my lord, interview.
They cannot go beyond rule 1, sub-rule 1. Right.
But whether his ACR is good or bad, whether it can be decided, whether it can be
But
decided.
where is the fact that marks were assigned to the candidates? Where is that?
Well, in the affidavit, my lord, filed by the BTC.
BTC, page 65. Running page 65. Starts on paragraph 9, page
नहीं
64.
जाएंगे. Which one? 65.
Operative part 65, Lord.
Had conducted an interview by forming 4 numbers of interview boards and by taking into consideration factors such as service experience, ACR, and performance in the personal interview score as per resolution 4 held on. But these are not to be considered.
This performance includes the ACR. The ACR, where,
ACRs are annual confidential reports.
confidential, where his performance is graded, my lord. Whether it's good, bad, best, very good, or something has to be
By
seen, my lord.
taking into consideration factors such as service experience. This should not have been there.
Yes, the BTC has elaborated so much, but ACR includes this performance.
Comma ACR. They are
ACR
not
yes.
saying that the ACR.
But
Comma ACR.
Yes, ACR includes this performance also. The ACR is, my lord, prepared on the basis of performance of a candidate.
But they are
Well, it says about
disjunctive.
experience and ACR. Experience, my lord, it comes with
Experience, comma ACR and performance in the personal interview. Score as per resolution 4 in the DPC meeting, Departmental Promotion Committee. But it should be district what?
district wise.
It should be DSC, District Selection Committee.
Yes.
They both are same or what? District Selection Committee and Departmental Promotion Committee? The requirement is that District Selection Committee has to do it. Here, Departmental Promotion Committee did it by conducting an interview. And subsequently, DPC selected 35 candidates out of 77 candidates who appeared. Reiterates the fact that petitioner was found not selected by the said DPC, BTC, and further respondent has secured a higher 50 marks for promotion to the post of so-and-so. Where is the requirement that the board has to assign marks? Interview board?
Well, there is no requirement as per the.
No, the procedure is not properly followed.
Well, I'll come up with this, my lord. Your lordship perhaps is rising.
Okay, 2 minutes, I'll come back. I don't think so. Sub-rule 1 is followed.
I'll satisfy your lord.
Okay, let me be clear with the first issue, whether DPC and the SSC, whether DPC can do the exercise which is required to be done by the district selection committee. Acha, see is rule 16.2. Rule 16.2, Constitution of the board. There shall be a district selection committee in each district for selection of principal, headmaster, so and so. Okay. And it will be comprised of DC, inspector of school, one retired, one principal, one headmaster in addition. So that is a district selection committee.
This-
But here the exercise is done by the DPC.
This-
Departmental Promotion Committee, as far as I know, that's an internal body who will give feedback for promotion. And this is actually a board that has to be constituted for a particular purpose.
If I may bring your lordship to
Hmm.
Rule 15.
Rule
15, my lord.
15, yes. The post of assistant headmaster and the assistant promotion. These are required to be done by the DPC. That's an internal body.
From the candidates, district wise, my lord.
Hmm.
District wise.
Employment promotion against graduate teachers of the same school.
On the recommendation of the district promotion.
Promotion committee.
Constituted under Rule 16.4, my lord. If I may take your lordship to Rule 16.
Hmm. Here it is done by whom?
Well, as per the rules.
Departmental promotion committee, not district promotion
Maybe
committee.
the word is written, my lord, DPC, my lord, but as per Rule 16, the committee was formed. Rule 16.4 says district promotion committee.
But then under rule 14, it has to be 16.2. 16, it has to be district selection committee constituted under 16.2. 16.2 is district selection committee. You are pointing rule 15, which is district promotion committee. There's a
Well, this-
difference,
Well,
right?
Lordship, Rule 15 is in respect of
Assistant
post
headmaster
of assistant headmaster, Lordship.
and
which is not
assistant
applicable.
superintendent.
Yes,
This is not the
applicable.
case here.
And
Ours is a selection for the post of principal.
headmaster, which is
Headmaster.
So first of all, that DPC is wrong.
for the time being, if your lord, therefore lordship to paragraph 4 of the affidavit filed by the BTC, running page 62. Here we
Yes.
clarified that the Department of Promotion Committee has been constituted which shall serve the same purpose as district promotion committee.
Where?
Running page 62, lordship,
Paragraph?
paragraph 4.
The deponent makes to deny the same as being untrue, as the BTC authority had constituted a departmental promotion committee by notification dated so and so for the purpose of promotion for the post of headmaster, which serves the same purpose as district promotion committee, which is referred to under 16.4. But we are not concerned with district or departmental. We are concerned with district selection committee.
but my lord, he is not challenging the constitution of the committee. He is not anyway agreed by
No,
the constitution of the committee.
no, he may not challenge. That is what I have found out. He has not prayed.
Yes,
He had
sir.
not,
And it is not even his case.
not even his case, he had not
And
submitted
he has
also.
participated in the selection process, which he cannot later on, my lord, challenge.
But then the entire constitution is wrong. The select list will go.
Then, my lord, the other affected party should be added as a party respondent before your lordship decides to, my lord, cancel the select list. They would be the affected parties. They are the selected candidates as per the select list.
But the selection is totally wrong here.
That is not the case of the private respondent also, lordship.
It is none of our case.
It is
not
there
challenge
to respond to your petition. It's not their case.
Now the BTC has to support that the constitution is.
Okay, we will not go into the entire gamut of the thing, but then since the select list is wrong, they should do the exercise afresh as far as petitioner is concerned.
That is my precise prayer.
But then the select, if your lordship cancelling the select list, the entire select list your lordship is cancelling. Is as because my lord, DPC is not well properly constituted as per the act, my lord, which is not even their challenge. The other affected candidates, my lord, who have been selected and been serving the, my lord, school, they would be affected. They are not the party respondents before this honorable court. They will miss the, my lord, fair hearing.
It's okay, that will be seen in some other case. But as far as he is concerned,
But he is concerned, but he is concerned only about the seniority.
because he is there in the seniority list.
Then, my lord, I have other submission to make. My lord, this seniority list, my lord, is prepared, my lord, district-wise, not school-wise. He cannot be aggrieved by the selection of a single candidate in a particular school. If he is aggrieved, he has to be aggrieved by the selection of other candidates who are junior to them. There are as many.
That you have seen, you need not repeat.
There are
But,
as many as 5 candidates who are junior to him, my lord, who has been selected ahead of him because of the performance in the interview.
It's
And
okay,
the
that you
HCF.
have said. Now what I'll do is, I've heard you, what else you require to place?
Your lordship,
Because what I think is, as far as he is concerned, he is there in the seniority list, final seniority list above you. Above you or others, we are not concerned, but then he was in the seniority list in Udalguri district. Where is the final seniority list? This, right? Where he is placed at 50. Where he is placed at 50. I'll not go to you.
Page 73.
He is placed at 50. And since the select list prepared after the seniority list is not proper, so I will direct the authority to reconsider the position and to follow Rule 14 and prepare a select list
if I have understood,
placing him at the proper position. That's all. I'll not go to anyone else because it is his writ. Right.
all right.
But on the face of it, this entire selection process is wrong. District wise. BTC also does things.
But the constitution of the committee as per the rules, Rule 16. there
Where is the Rule 16 followed? Rule 16 speaks
is a-
of state selection.
It is only the word they have used here, my lord. The rule has been followed because in the affidavit, they have filed the affidavit on oath.
They say that DPC is equal
DPC
to district selection.
The choice of the word may be wrong, my lord, but the purpose of the constitution of the committee is as per Rule 16 of the rule.
No. How can that be? It is as per Rule 15, District Selection Board. They are not aware.
My lord, the district selection committee has been, my lord, constituted as per the rule, my lord, they have stated in their, my lord,
There is a
affidavit.
question of district selection committee. There is a question of the requirement is district selection committee as per 16.2.
Yes.
And 16.2 provides what? 16.2 is district selection committee by engaging these persons. Now they have done is what? District promotion committee.
Well, these persons are, my lord, engaged in the committee. They are the members in the committee. There is no dispute to the fact.
Where is the formation of the committee? And the correction that they have made is district promotion committee, not
Well,
district selection
The
committee.
members are as per the, my lord, requirement of rule.
Doesn't matter. So why will the rule make a difference between district selection committee, district promotional committee? See, the 15 talks of will be filled up from the candidates on the recommendation of district promotion committee, right? DPC. DPC under 16.4.
16.4. my lord, it's
16.4, you see?
promotion
District
committee,
promotion committee.
vice principal, headmaster.
For
District promotion
promotion of vice principal,
headmaster.
headmaster, superintendent.
This
This
the-
is not the requirement under 14. 14 speaks of 16.2, not 16.4. 16.2. 16.2 is the district selection committee. Maybe the members are same, but the proper committee has to be constituted. This is district
my lord,
selection committee.
This is for promotion, my lord, and this is for selection.
Huh?
There shall be district selection committee in each district for selection of principal.
Huh?
And this is for promotion of principal headmaster.
Actually, it should be selection of principal.
And this is for, my lord, principal and headmaster promotion, selection, and it is for promotion. This is-
Whatever it is, we have to go by Rule 14. Rule 14.
my lord, the post of headmaster is a promotional post.
Shall be filled up by promotion by a district-wise selection list on the recommendation of district selection committee constituted under 16.2. Don't go to other sections. 16.2 provides of what? District selection committee who will recommend, and the select list will be prepared. 16.4 is different. 16.4 is district promotion committee. And there the members are less. Deputy Commissioner, District Elementary Education Officer and Inspector. Here, District Selection Committee. So enough of hearing. Let me start dictating. Whatever you have to say, you say.
What is coming from this?
Nothing will happen to you. I'll not disturb you. But then they have to prepare properly in accordance with law, the select list, and give him the right position.
However, my lord, whether your lordship will go beyond the pleadings made in the writ petition, my lord, that is one of the pertinent questions.
There is any other order or orders we
Yes.
take resort to.
Resort to, well, but this is not his case, my lord. Whether your lordship will embark into the issue which has not been highlighted and there is no affidavit opposition file in the pleadings, my lord, because naturally there is no pleading regard to that. Had there been pleading
Doesn't
regarding
matter if it comes to the notice of the court and when it is law point is involved. So why do you want pleadings on law?
but whether it has been constituted or not, if there is no pleading, there is no chance of affidavit opposition filed by the other side. my
But
lord.
it is writ large on the annexures itself that district selection committee has not done it.
But the members present there in the selection committee where he has participated are the members, my lord, as per the rule, my lord, 16.2. If the members are present, my lord, name of the
What
nomenclature.
do you mean to say that the committee is as per which rule?
My lord, this rule.
16.4.
16.2, my lord.
16.2 is a district selection committee.
Yes.
Well, you mean to say that the nomenclature is wrongly used?
Nomenclature is not wrongly used in the affidavit, my lord. For this, my lord, the entire selection process, my lord, may not be affected because the members present in the selection committee, even if, my lord, the petitioner knows, my lord. Had there been no member as per 16.2, he would not have participated.
Okay, he has participated. Employees have
Once he
lesser
has
bargaining
participated
power.
for a blink of moment, my lord, he cannot even challenge the process. He cannot even say that no, the committee was.
That is a settled principle. Failed candidate should not again challenge. That is okay.
And the committee, the members present in the interview in the committee are the members prescribed under Rule 16.2.
16.2 members will do. 16.2.
Members are there, my lord. Only the name, my lord, nomenclature is wrongly used in the affidavit and opposition.
See, 60, what do you say? 14.3, the interview. The district selection committee shall hold the interview.
They held the interview, my lord. These members.
Members, I don't know what members were there. How do you know where can you show that members are those? Any annexures to that effect?
Lordship, there is no record placed by the BTC.
Well, now he is taking
Probably
the my lord,
submitting that-
pleasure of the record, non-availability of the record.
Doesn't matter.
Whereas
Don't make it too confusing. I'll dictate the order.
May I submit?
Heard, Mr. Yes.
He's arguing on a point which I have neither raised before Lordship.
But this is a law point, not required.
The law point, Lordship made observations. If that is so, the entire select list goes by itself, including the right of the respondent number 7, where I need not read anything, Lordship. But that is not my case. My case is precisely that she was just right junior to me. She has been recommended. I have not been recommended. I should have.
No, she has been recommended you, Choro.
Please, sir.
That you are not recommended in spite of your position in the seniority
Exactly,
list.
exactly.
That is what should be
And
your case.
PTC has
Forget about
considered
others.
Way beyond the requirement of Rule 14, which only says seniority and consideration of ACRs. But they, in the affidavit, they have specifically stated they have taken into consideration other things, allotted marks, which cannot be.
Okay, that I have gone through.
Yes.
Yes, you have something.
I'm for the BTC lordship.
Acha, let him complete.
Lordship is
let
aware
me
that
submit.
if
Oh,
any
wait.
marks has to be done, any other criteria has to be done, that has to be there by way of rules.
That I have seen. That I
Yes,
have seen.
Lordship.
You need not
Unless
repeat
rule
it.
provide for those considerations, the DPC or district selection committee cannot go beyond that provisions, Lordship.
Okay. Yes.
My lord, regarding DPC lordship, section is correct, lordship. Nomenclature is something else, lordship. I'll take instruction on that, lordship. And before
No more instruction. You have filed your affidavit.
Lordship.
I have heard 2 days. Now no more further adjournments. Because you have.
one aspect, lordship, I have got instruction today itself, lordship, that is main thing, lordship. I may.
Show me that.
Our original record with.
Wait, I'll just go through. I'll just go through.
No, this is personal.
No, this, what has, court has to go
It's
to do it.
necessary
He is
to be-
calling for the records.
Otherwise, Lordship, entire, if it is entered selection process gone, there will be something.
No, no, I'm not interfering. There is no prayer for interfering with this entire only that he is aggrieved. So in order to
And more
give him some
particularly,
relief, I'll.
Lordship, Rule 14 has been followed. As per this, our affidavit, Lordship,
Mm.
has been followed.
How?
How it is, Lordship, already stated in our affidavit, paragraph number already, your Lordship also
Mm.
gone through our learned, what my learned friend submitted.
Mm.
Lordship. Paragraph number 9,
Mm.
your Lordship also gone through this affidavit as 66.
Mm.
Already stated as per the Rule 3,
Mm.
Roman 3 in the said Bill 2018
Mm.
last stated. And it is in the
What is amended in 2021? So what is the amended rule?
amended rule stated, Lordship. Though stated, this is. And however, Lordship, please come to the paragraph number 13, Lordship.
Mm. Paragraph number?
13, page number 67, Lordship.
Yes, 30.
May I read this paragraph, Lordship? That as regard to the statement made in paragraph number 12 of the writ petition, the deponent beg to state that although the petitioner has adamantly tried to establish herself as being senior to the respondent number 7, in actually the Department of Education during the evaluation of candidates in the process of promotion to the post of headmaster, public headmaster gives the precedent to the candidates having both seniority come efficiency, as seniority is not the only sufficient criteria or satisfactory ground for the said promotion. Further, the headmaster has to maintain a protocol of duties and responsibilities to keep a dignified atmosphere of the school for the best interest of the students, and therefore merit-based promotion for the candidates who have been qualified of the exceptional performance and educational leadership is crucial, and that is why seniority is not sole criteria for promotion, Lordship. Let the record come up with us, Lordship. Record is
necessary. You are
Record
telling after
necessary.
3-4 hours of.
And DPC, Lordship, regarding DPC, I will clarify it.
1 second, wait.
DPC, once DPC selected the private respondent, Lordship, once selected and participated by the writ petitioner, Lordship, petitioner got 35 marks less than the present private respondent, Lordship, respondent number 7. That is clarified, Lordship, that is why. Records also required, Lordship.
Not now. What records required? Yeah, right. Heard Mr. Todi. What Todi? What do you?
Dr. A. Todi.
Huh?
Dr. A. Todi.
Dr. A. Ankit.
Yes.
Dr. A. Todi, learned counsel for the petitioner, and Mr. For this, for R7 now. And Mr. Your name, please, BTC. Your name?
Musahari.
Mr. Mushari, learned standing counsel for BTC, representing respondent number
Lordship,
2. 2, 3, 4, 5, 5. 6 also.
2 to
Udalguri.
6 and 8. 2 to 6, Lord.
2 to 6. And for 1, Miss S. Kumar, learned standing counsel for secondary, no, for government advocate, right? For elementary education, representing respondent number 1. And Mr. Biswas, what Biswas you write? NS. S. Biswas, learned counsel for respondent number 7. And 8, DPC, Departmental Promotion Committee, BTC, you only appear.
I'm
A to D for BTC
Wait.
council, huh?
wait, also.
By this application, under Article 2 to 6 of the Constitution of India, the petitioner has prayed for setting aside and quashing of the select list dated 12/3/2024, issued by the Secretary, Boroland Territorial Council, Kokrajhar. Full stop. The petitioner has also challenged the order dated 13/3/2024, issued by the Director of Education, Bodoland Territorial Council, by which the petitioner was not promoted to the post of headmistress of the Barkola High School, Udalguri, and in her place, respondent number 7 was promoted. The petitioner has also prayed prayed for a writ of mandamus, directing the authorities to promote the petitioner to the post of headmistress of the said school with all the service benefits. With the further prayer that the authorities should not give effect to the impugned select list dated 12/3/2024, as well as the promotion order dated 13/3/2024 in respect of the said school. The case of the petitioner is that hey, AC ban कीजिए बाबा, मैं ठंडा पड़ी से हाथ सब AC ban कीजिए. I'm switching off the AC. Perhaps there will be no problem, right? For some time. My hands have become too cold. Okay, so the case of the petitioner. The case of the petitioner is that the petitioner was appointed as an assistant teacher in the great pay wide order dated 8th of December 2010. And the said appointment had the approval of the Government of Assam Education Department and with the concurrence of the Finance within bracket SIU Department. Full stop. Thereafter, the petitioner joined in the said post on 13/12/2010, as is reflected in the joining report issued by the headmaster of Barkola High School. Hey, high school to dislu ni naam. She was appointed as the assistant teacher at Barkola High School. Did you see? Appointed as the assistant teacher and posted at Barkola High School. In the grade scale of pay, it is no. Thereafter, the petitioner joined as headmistress, in-charge headmistress, as joined as in-charge headmistress of the said school, wide order dated 1/1/2024. Wide order নহয়, wide joining report. Wide joining report dated 1/1/2024. And the said joining was in pursuance to the letter by the DE Kokrajhar is what? DE is what? District what?
District Director of Education.
Director. By the letter dated 22/12/2023 issued by the Director of Education, Kokrajhar. Thereafter, the seniority list. Thereafter, this is what? 8/7/8/23 is the seniority list. This is not the final, provisional, no? Thereafter, a provisional gradation list of assistant teachers of the high schools. No, not thereafter, right? Before the said before the said joining of the petitioner to the post of in charge headmistress, a provisional gradation list of assistant teachers of high schools under the inspector of schools, Udalguri district, was prepared on the basis of the appointment order as well as the joining date and other factors. And in the said provisional gradation list, the petitioners appeared at serial number 46 of the same. And that thereafter, a final gradation list was prepared on 16/12/2023, wherein the petitioner appeared at serial number 50, a gradation list in respect of the district of Udalguri, in respect of the district of Udalguri, and the petitioner appeared at serial number 50. Para. Thereafter, the senior most teacher is hereby allowed to in charge of him. We have not annexed the annexures properly. This is the order of the Director of Education by which the petitioner was given in charge headmistress post. This has come later after she joined.
No, Lordship, page 25 is the order.
By the Director of Education giving her in charge headmistress.
Yes, Lord. Then
So this should be
page
before her joining. Right. Hey, to joining to me
page
report
26
लिखिल
is
बस.
joining.
Page 26 is joining.
Yes.
But what about this page? Wait. This joining report you see? Page number 20. That is also in charge headmistress. Runumi Priya Devi. Same or what? Same.
Page 20 is
Not same exactly. This is joining report.
this is joining.
And
page
this is
26
handing over.
handing over.
Same. What? This is letter dated what? 1/1/24. Oh, no, no, no. This
See,
is.
There was handing over and there was also joining it.
আচ্ছা এটা প্যাৰাগ্ৰাফ ওপৰত লিখি থৈছো এইটো যে জইনিং দিলো যে ইনচাৰ্জ প্ৰিন্সিপাল তাৰ আগত তাৰ পিছত হেণ্ডিং অভাৰ এণ্ড টেকিং অভাৰ চাৰ্জ এণ্ড জইনিং ইজ চেম থিং বাট দিয়া Thereafter, the Director of Education, BTC Kokrajhar, had issued a notification on 14th of February 2024 for holding for informing all the eligible candidates that an interview for promotion for the post of headmaster and headmistress of provincialized high schools under Udalguri and other districts to be held on 19/2/2024. Which informing that so and so, which was supposed to be held on 19/2/2024, was rescheduled and was fixed to be held on 20/2/2024. In pursuance to the same, the selection process was conducted and a select list was issued on What on which date? 13/3/24.
12/3/24,
On 12/3, the entire list that you had given.
Lordship,
On 12/3/2024,
and intimated on 13/3/24.
12/3/2024, wherein for the district of Udalguri, 35 numbers of candidates were selected for the post of principal as well as headmistress. What? For the post of headmaster / headmistress for the provincialized high schools of the said district. It is stated by the petitioner that petitioner did not figure in the said select list. After publication of the said select list, by order dated 13th of March 2024, the ceremonial distribution of promotion was directed to be held on 14/3/2024, and the selected candidates were called on the said date. It is para. It is also the case of the petitioner that respondent number 7 was although appointed on the same date as an assistant teacher. Mr. Sharma, R.P. Sharma, Mr. Sharma, who is this? Mr. Sharma, you're waiting for a matter. But then this dictation will take some time. You can come back at 2. What is your matter? 41. Acha. So can your matter be taken up on a later date? Acha. Okay. I'll defer that matter then. Okay. Yes, then. Although appointed on the same date as assistant teacher and in the same school, that is by order dated 8th of December 2010, it is stated by the petitioner that said respondent number 7 joined as the assistant teacher in the said school. Where is the joining report of respondent number 7? Not there. Acha, joined.
What we find in the gradation list?
Joined on
Page 50.
18/12/2010. That is 5 days after the petitioner had joined in the said post. It is also stated by the petitioner by showing the gradation list, by showing the provisional gradation list, that respondent number 7 was listed below below the petitioner at serial number 47 of the said list. And it is also seen in the final gradation list that respondent number 7 appeared below the petitioner at serial number 51. By notification dated 16/12/2023. Para. It is also the case, same there. It is also the case of the petitioner that the petitioner was given to hold the post of in charge headmistress of Borkola High School by the order dated 22nd of December 2023 by the Director of Education, BTC Kograjhar. Since she was senior most assistant teacher of the said school. The petitioner therefore states that in the selection process in which she appeared, she was not selected, and in her place, respondent number 7 was, no, not in her place, she was not selected in the select list. She was not selected. Full stop. Para. Mr. A. Todi, learned counsel for the petitioner, submits that the selection done by the authorities was without following the rules, that is, Assam Secondary Education within bracket Provincialized Schools Rules 2018. Hereinafter stated to be 2018 rules.
It will be service rules.
Oh yes, again this book doesn't contain service. Service rules, 2018. Full stop. He states that as per Rule 14 of the said rules, the post of headmaster of a high school shall be filled up by promotion from amongst the candidates, from amongst the graduate teachers, from amongst the graduate teachers as per this district-wise seniority list prepared on the recommendation of the district selection committee constituted under Rule 16, Sub-Rule 2. And that for selection, see, they are not clear while they make these rules. At one point they will say promotion, at other point they will say selection. What is this? This is the way rules are drafted. See, it is said promotion, then the next line selection. They're not done. Selection, promotion are two different things. Okay, right. He further states that the criteria that has to be adopted for promotion slash selection of headmaster and superintendent, the criteria should be, the criteria no criteria agote kolo no, the criteria ki kolo no, the criteria that has to be followed while promoting or selecting the headmaster and the superintendent should be based on seniority and satisfactory annual confidential report for the last 3 consecutive years, as per procedure provided under Sub-Rule 3. He stated, full stop, he stated that this criteria was not followed during the selection process. He submits that although an interview is required to be held as per Rule 3, Sub-Rule 3, and a select list has to be prepared, double the number of vacancies of the concerned district. But the criteria as mentioned in Rule 14(1) has to be followed strictly. Full stop. The Learned Counsel, by referring to the affidavit filed by the BTC, had stated that an interview was held of all the candidates applying for the post of headmaster, including the petitioner, and marks were given to them, and it is stated by the BTC authorities that respondent number 7 got 50 marks and the petitioner got 35 marks less than respondent number 7 out of total 80 marks. He as such submits that the procedure adopted by the DPC is incorrect, and the set criteria not being adopted, the set selection of respondent number 7 and depriving the petitioner was incorrect. That is all your submissions, right? Nothing more. On the other hand, Learned Counsel for the BTC submits that the Departmental Promotion Committee, which is clarified in its affidavit, that the same may be read as
Paragraph number.
not, which is clarified, no? And is stated that although a departmental promotion committee was constituted, but it served the same purpose as district promotion committee. This cannot be also correct. District promotion committee is in respect of the entire district. Departmental is internal to the school, from head teacher to in-charge principal, those things. How can they be for the same purpose? Read the law properly. Okay, can be for the same purpose as district promotion committee. Yes. Oh, yeah. Oh, departmental promotion had constituted a departmental promotion committee who would serve the same purpose as district promotion committee as referred under Rule 16(4) and Rule 14 of the 2018 rules. It was like a beginning to can I get this sentence to? Which is Departmental Promotion Committee states that Departmental Promotion Committee is clarified. And I get which to my dear. Has clarified that ki koisa? Okay, ठीक है. It would serve as the same purpose as district as so and so. So and so. He further submits, full stop. He further submits that the said DPC for the promotion to the post of headmaster, headmistress in provincialized high schools held a meeting on 4/3/2024 it was not even said that it was an interview. It was held a meeting. Right. Held a meeting on so-and-so, and 35 candidates were selected. And now, wherein 35 numbers of candidates were selected for the promotion to the set post of headmaster, headmistress for the entire district of Udalguri. And it is further stated that writ petitioner having got less number of marks. Oh, no. And marks were allotted, and marks were allotted to all the candidates. By allotting marks to all the candidates. Wherein 35 numbers were selected? No. By allotting marks to all the candidates. It is also stated, he also stated that petitioner having obtained lesser marks than respondent number 7, respondent number 7 was selected and petitioner could not be selected for the said post. The Learned Counsel further submits that although the petitioner was senior to respondent number 7, but the Department of Education, after evaluating various considerations such as evaluating various considerations of the candidates, gave precedence to the candidates having both seniority cum efficiency, as seniority is not the only sufficient criteria for the said promotion. It is further stated that headmaster has to maintain protocol of duties and responsibilities to keep a dignified atmosphere of the school and based on merit-based promotion and on merit-based promotion for candidates who have qualities of exceptional performance was considered. Full stop. This entire paragraph is also incorrect. Do you know what is merit cum seniority, seniority cum merit, merit cum suitability with regard to seniority? Do you know all this? Merit cum ACR's consideration. So merit will come first. And the candidates who will have ACRs of same. Good. Then within the two, the senior will be considered.
Yes.
So what is this? Merit comes later. Merit comes before seniority.
File before joining will.
What joining me? You should have withdrawn this and filed a new one. Okay.
That's why I.
Okay, these are the submissions. Etu hoga. Mr. S. Biswas, Learned Counsel for respondent number 7, submits that Rule 14 of the said rules of 2018 was followed and an interview was held. And in the said interview, the candidates were, the performance of the candidates were evaluated and selection list was prepared. He submits that the prayer of the petitioner as well as the pleadings in the said writ petition were different to what the Learned Counsel for the petitioner submitted before this court. He states that the prayer was for setting aside the entire select list, which however cannot be done in view of the fact there are many junior candidates to the petitioner who were appointed to the post of headmaster in different schools within the same district, and that the petitioner had challenged only the appointment of respondent number 7. Full stop. He submits that since petitioner and respondent number 7 were working in the same school, the challenge is made. However, he submits that the appointment has to be done in different schools within the said district, and the incumbents in the same school will not matter. He further submits that although the exercise under Rule 14(1) has to be done on the recommendation of the district selection committee constituted under Rule 16(2), recommendation বলছে কৈছো এখন কি হল recommendation for promotion to the post of principal মাজত লিখি দিয়াচোন for the post of headmaster, recommendation for promotion to the post of headmaster, should be done the exercise of পিছত দিয়া question sentence no has exercise no the exercise for promotion to the post of headmaster hetu likhile ho majo exercise for the post of promotion to the for promotion to the post of headmaster under rule etu ho jabo has to be done on the recommendation of the district selection committee as constituted under Rule 16(2). However, in the instant case, the same was done by district selection committee but the members constituting the district selection committee are the same as that of the members which have to be present in the district selection committee. Hey, to district promotion committee hobo, I am also getting confused with the words. This is district promotion committee, prothom to district promotion committee, tarpisa district selection committee. Actually, the nomenclature of promotion is wrong. Headmaster should be always selected, right? Promotion is wrong. So promotion is only from assistant to assistant teacher to vice principal or whatever in charge headmaster. But then they are not clear with selection promotion, so that problem has happened. That's the whole. And what are your other submissions? These are
Maintainability of the repetitions because he is challenging the entire select list and the.
he has also raised the issue of non-maintainability of the instant petition on the ground that in the prayer, I have already said that in the prayer, the entire selection process is prayed to be set aside, whereas the council has prayed for.
No, the selected candidates are not made part.
Non-maintainability of petition on the ground that that having challenged the entire select list, the other candidates were not made as party respondents. These are all. You pass it on. He relied on the judgments. This is 1 o'clock. We will continue at 2, Mr. Vishwas, and we'll finish it. Okay.
For your lordship rises, Milord, regarding item 10. We both sides are having some predicaments next up. So, matter will be taken up next Wednesday, my lord.
Huh.
Item 10.
Okay, heard Mr. PJ Fukom, learned counsel for respondent.
Yes, my lord.
Item 10. Acha, for respondent. And Mr. B. Chanda, learned counsel for the petitioner. On a joint prayer made by both the parties, list this matter.
On
26th, on 26th of May, 2026. I'm in the midst of a dictation. So it will take, I think, 10-15 minutes.
No issue.
So I'll take you up after immediately after this. You can go somewhere and come back. কি কৈছিলো last? আৰু কি আছে? এক দুই হ'ব দিয়া চৌধুৰী ছাৰৰ পিছত মাতিলে হ'ল। Yes. What was? Judgments that you rely to substantiate his argument, Mr. S. Biswas has relied on the following judgments. এটা দুটাকে লিখি দিবা আৰু I've heard the counsel and I've gone through the records. You want to refer to those judgments, or I will myself read and
One,
how many?
I will not read the all the judgments, but one very important judgment is there. 2008 4 SCC 619. Page
Yes.
77. The paras, my lord, I will be relying paragraph 58,
58.
58, 59, 60 and 60. If I may read, my lord, two of the paragraphs, my lord. Page
No,
1,
I'll read it. It's okay.
103, paragraph 58.
Yes, I'll read it.
It is settled law that in such writ petition, a roving inquiry on the factual aspect is not permissible. The High Court not only engaged itself into a non-permitted fact-finding exercise, but also went on to rely on the findings of the amicus curiae, or as the case may be, the scrutiny team, which in our opinion was inappropriate. While testing the fairness of the selection process, wherein thousands of candidates were involved, the High Court should have been slow in relying upon such microscopic findings. It was for the High Court to place itself into a position of a fact-finding commission, that too more particularly at the instance of those petitioners who were unsuccessful candidates. The High Court should therefore have restricted itself to the pleadings in the writ petition and the say of the respondents. Unfortunately, the High Court took it upon itself the task of substituting itself for the selection committee and also in the process assumed the role of an appellate tribunal, which was in our opinion not proper.
So I will not go into all this because here, see, I mean, the High Court has gone into away from pleadings and all. So whatever he has pleaded, I'll confine my judgment to that only.
I'm applying. One small paragraph, my lord. Paragraph 63.
63.
Yes, my lord. And 60, my lord. 60, my lord. Small paragraph. In our opinion, the first basic things for such a selection process would be the lack of bona fide, or as the case may be, malafide exercise of powers by those who were at the helm of selection process. Both the courts below have not recorded any finding that they found any malafide.
Okay, this will not be applicable because we are going into the law. So no malafide findings or something. The law is not being properly implemented.
What I am on, my lord, there is no materials before this honorable court to come to a conclusion that, my lord, the DPC and the selection committee was not held constituted as per 16.2, my lord, because the repeated submission of the BTC, my lord, they have followed. There is no material available before this honorable court. Those to say that the selection committee was not constituted as per rule, my lord.
Because the impugn order only shows it should be district selection committee. But it was passed by somebody else.
The nomenclature, the selection list has been prepared, my lord. And one more
The
paragraph.
nomenclature will matter. We will not go into who were the members. We will see whether proper committee was constituted. It was not according to rules. I'll write this, okay?
And 63, my lord, one small. Similarly, we are not satisfied with the course taken in inviting the objections of the selected candidates who were never ordered to be made parties to the regulations.
This also I will not go into.
Yes.
I'll not, other candidates will not be affected. Only this part petitioner will be.
So your lordship will not interfere with the, my lord, appointment of the respondent number 7.
That we will not. I'll not interfere with it. I'll just tell the authorities to properly follow the law.
Yes. And the
And if it
selection
is
list
required,
selection list will continue.
if it is required, they'll have to publish a fresh selection list. If it is required, they will have to consider according to the law. Law is not being applied properly. Let me see what I order. I also am not very sure.
Lordship,
Okay.
my friend is submitting in the midst of the judgment, passing of the orders. these additional submissions are not supported by the affidavit filed by the respondent. Lordship.
Mm.
These are submissions.
Okay, don't
without the
worry, I will give
These
my
are
comments.
submissions on law, point of law.
Now he's saying submissions on law.
Let me
Whatever is
add some of the
advantageous.
benefits box because I am not able to controvert that points and that is also not on facts.
It's okay, it's okay.
You should not have challenged the entire selection process without adding.
Give me that book back.
Selected candidates, party respondents.
Give me that compilation back. Etu eong disu mon. Tumi likhi diba, these are the judgments which he has relied. 10টা মান আছে. Into the records. It is noticed. No, it no. At the outset, since the issue involved in the instant petition is for the selection to the post of headmaster of the respective school, of the concerned school, and the relevant law governing the said subject is Rule 14 of the 2018 rules, comma, Rule 14 is quoted herein below. A bare perusal of the said rule makes it clear that promotion to the post of headmaster should be done amongst the graduate teachers as per the district-wise seniority list. And on the recommendation of the district selection committee constituted under Rule 16.2. Rule 16.2 may again be referred at this juncture. Rule 16.2 provides that there shall be a district selection committee for each district for selection of headmaster as well as other posts, and the said committee would be constituted with 6 members mentioned therein. Rule 16.2 is quoted herein below. Explanation to diba, a taller inverted comma, mo interest. I'll flag it. Etu hol 16.2, are orange, Etu hol 14.1. Rule 14.1 koriba, Rule 14.1 is quoted herein below. 1, sub-rule 1. It is further provided under Rule 14.1 that the criteria to be applied for the selection of the headmaster is that the seniority along with satisfactory annual confidential reports for the last 3 consecutive years has to be considered. And it is also provided that the procedure should be followed as provided under sub-rule 3 of Rule 14. Sub-rule 3 provides, amongst others, that district selection committee shall hold an interview category-wise and prepare a panel of select list. Prepare a panel of select list, double the number of vacancies for each district. Full stop. The duty to prepare the select list was saddled on the district selection committee. The said provision is in consonance with Rule 14, Sub-Rule 1 of the rules of 2018, which also provides that on the recommendation of the district selection committee, the promotions to the post of principal of a headmaster would be made. In the instant case, however, it is seen that select list that is the final gradation list of assistant teachers published on 16/12/2023 reflected the name of the petitioner at serial number 50 and and by following the mandate of law, that is Rule 14(1), the promotion to the post of headmaster should be considered from the seniority list and on the recommendation of the district selection committee. Further, the district selection committee is mandated to hold an interview and prepare a select list. Full stop. Since the requirement for selection to the post of headmaster is provided for in sub-rule 1 of Rule 14, and the same should be based on seniority and satisfactory annual confidential report for last 3 consecutive years. It is a normal corollary that the district selection committee would consider the same while holding the interview by virtue of sub-rule 3, by virtue of sub-rule 3 of Rule 14. It is seen in the instant case that the select list this select list is double the number of vacancies or no? It is as per the vacancies.
I'm not aware.
Huh?
I'm not aware. That is to BTC to submit that.
But
Yes,
it is the final select list out of the 70 candidates that were shortlisted.
This is the final select list, and you don't have annexed, you have not annexed the select list given by the district selection committee double the number of vacancies. No, it's not there.
BTC is
It's not there.
submitted that.
Okay. ठीक हो ना? In the instant case, as per the said provisions, it is as such required that the district selection committee would hold the interview and prepare a select list double the number of vacancies of the concerned district. However, the said select list which is prepared by the district selection committee is not on record. It is a full stop. It is further provided under sub-rule 3, clause 4, Roman 4, Roman 4, that the select list so prepared by the district selection committee shall be submitted to the state selection board, and the state selection board, after necessary verification, is required to prepare a district-wise select list equal to the number of vacancies and publish the same in the notice board. And pursuant to the publication of the said select list, the appointing authority shall issue promotion orders as provided in sub-rule 3, clause 5. It is stated in the affidavit in opposition filed by respondent number 4, that is the BTC, that a departmental promotion committee, BTC, had held its meeting on 1/2/2021 . No, eta word diya no. BTC is a kolo departmental stated in the affidavit question. That the BTC authority, that BTC authority had constituted a departmental promotion committee on 1/2/2021 for the purpose of promotion to the post of headmaster, headmistress, and the departmental promotion committee, by holding a meeting on 4/3/2024 Where is that out of 70, 35? They have given 35 only.
Yes, 35.
You have said 70 out of 35? No.
Page 44.
Page
44.
44.
Total selected candidates 35. For the entire 4 districts.
Entire 4 districts.
Kokrajhar, Chirang, Baksa.
No.
Sorry, Malan, only for the Udalguri district.
Only for the
35. For district wise selection committee, Malan, they will sort out 70 candidates, double the Malan vacancy.
So wait. Where is Udalguri? Udalguri is
47.
47, yes. Baksa, Udalguri, it was 35 candidates.
35 the selected candidates.
And how many appointments?
35, my lord.
35
This is
only.
the appointment.
Against the number of, double the number of vacancies not there.
Well, 70 candidates were shortlisted.
Where do you find
Vacancies
this?
were 35.
Where do you find this? 70 candidates were shortlisted?
As per the act, it's double the number. That's why. my lord.
Oh, that's why you have said.
Based on presumption, is making a
There is, it's not on record.
Where is his pleading, raising all this objection, my lord, orally now a presumption?
It's okay.
He has also filed the writ petition on presumption.
It's okay. Argument's over. It's okay. Okay, Kikolo. 4/3 is 4/3/2024. 24 published a list of selected candidates. Oh, no, published no. Recommended 35 numbers of candidates for the promotion to the post of headmaster, headmistress of high schools for the district of Udalguri. And it is further stated that the said departmental promotion committee in its meeting had evaluated the performance of the candidates no. And it is further stated that departmental promotion committee had conducted an interview by forming 4 numbers of interview boards and by taking into consideration factors such as service experience, ACR, performance in the personal interview, interview, gave marks to the various candidates. Oh no, it is pleaded 35 numbers out of total number of 77 candidates. Acha, who appeared in the interview. That is not the issue. Okay. As Kikulo? Candidates. And that finally, 35 numbers of candidates out of 77 numbers of candidates who appeared in the interview was selected. It is further stated that petitioner had got less marks and as such, she was not selected for the post of headmaster. In the said affidavit, the respondent had also stated that district promotion committee departmental promotion committee constituted for the purpose of promotion had served the same purpose as the district promotion committee. Para. However, the said exercise conducted by either departmental promotion committee or as stated by the respondent, that its district promotion committee was not as per the law provided in 2018 rules. As per 2018 rules, what is required is that the district selection committee formed under Rule 16, Subrule 2 of the said rules would prepare a select list, double the number of vacancies, and submit it before the state selection committee. In full stop, in the instant case, it was the departmental promotion committee or the district promotion committee, where again a difference lies, has prepared the select list and published the same. And on the said basis, selection is made. On a said basis, selection and promotion is made. It be stated here that although the said law point was not raised by the learned counsel for the petitioner, neither it was a pleaded case, but the same being an issue on law point, it is entertained by this court. Para. In the instant case, the departmental promotion committee Further, the contention of the BTC authorities that Departmental Promotion Committee has served the same purpose as the District Promotion Committee can also be not accepted in view of the fact the required exercise that needs to be done is by the District Selection Committee, which is constituted under Rule 16(2) of the 2018 rules. Even if we consider, even if this court considers that the District Promotion Committee has done the exercise, the same is also not acceptable. In view of the fact, the duties of the Departmental Promotion Committee is enshrined under Rule 15 of 2018 rules, where the District Promotion Committee is required to recommend for promotion to the post of Assistant Headmaster as well as Assistant Superintendent. The District Promotion Committee has got nothing to do with promotion to the post of Headmaster or Superintendent. And it is only the District Selection Committee who has to conduct. Para. Further, it is provided that District Selection Committee, after preparing a list of candidates, double the number of vacancies, should submit it before the State Selection Committee. It is seen, full stop, it is seen that the said exercise has not been gone into. And on the recommendation of the district and on the recommendation of Departmental Promotion Committee or the District Promotion Committee, the said list was published. It was not placed before the State Selection Committee. Where is the select list? This is the one. It is seen in the instant case that the Secretary of Bodoland Territorial Council, Kokrajhar, by letter to the Director of Education, Bodoland Territorial Council, Kokrajhar, had intimated that approval was received from the Bodoland Territorial Council for promotion of the candidates district-wise, letter dated 12th of March 2024. It is nowhere. It is nowhere reflected that that the select list so prepared by the committee who had conducted the interview, which according to this court, the same was bad, comma, was not placed before the state selection board. State selection board, huh? State selection committee ko is state selection board ko.
BTC is a transfer subject. So in this case, my lord, forwarding the names to the selection board of the state may not occur, my lord. Because here the director of education is the head of the, my lord, BTC. It is a transfer subject. So appointments will be made by the director, not by the state. Director of education, BTC.
Acha. However, to this an argument is placed that director of that the director of education BTC, director of education BTC, that director of education BTC is the concerned authority. In the Bodoland Territorial Council to issue the select list instead of state selection board. However, in the instant case, it is absent as to show, no, it is absent as to whether the select list prepared double the number of vacancies were placed before the director, and the director had issued the final select list equal to the number of vacancies. The said exercise having not gone into the selection made by the respondent authorities is not correct in the considered view of this court. Be that as it may, be that as it may, in the instant case, the petitioner has raised the issue of his non-appointment to the post of headmaster in spite of having the eligibility. This court finds it fit to direct the authorities to consider the promotion to the post of, what is the school? A post of headmaster in Barkola High School.
In my humble submission, he cannot choose in which high school he is to be appointed, my lord. It is district wise.
In any high school, this is correct. If it this court directs the respondent authority of the petitioner to a high school within the district by following the criteria provided under the rules and after conducting the necessary exercises. Any other addition, I'll make it. I'll think over.
Once your lordship has held that it was not.
See, there are so many predicaments in this case.
No, lordship.
I cannot set aside the entire select list. The other students are not there.
Setting up the entire select list. I am holding the in charge post for a time being. Based on interim order passed by this honorable court in the writ petition.
You are
still
continuing.
holding the charge. I am continuing. Now, so where lordship has held that it has not been in proper procedure, the impugned promotion order of respondent number 7 has to go.
Now, in that case, respondent number 7 all has to go.
No, particularly respondent 7 in this particular school. Likewise, I cannot claim in this school. Respondent 7 also cannot claim in this particular school.
Why are you against respondent number 7?
I'm not on
You
respondent
want
7,
to be a headmaster of a school.
She is
So,
just junior to me, next
mm.
junior to me.
Mm.
She is also eligible, I am also eligible,
Mm.
subject to consideration of the 3 years ACR.
Mm.
That I am not, and that is per procedure, the committee will look into and consider 3 years ACR. Now comes the seniority. On facts, I am senior to her. If I am selected, whether I am selected in the same school or any other school, likewise, she also cannot claim her selection in the same school.
See, as I said, there are many predicaments, nothing more than disorder. You see, Harikono, by following the criteria provided and other exercises to be gone into. This order is passed in the peculiar facts and circumstances of this case. Since the rules are not being followed, and the petitioner should not suffer because of that. Petition is disposed of. R7, I'm not talking of anything. Because in that case, all others will go. Your selection is bad. Selection is bad.
The selection of respondent 7 is bad for timing if I take an interpretation.
Respondent number 7 selection is also wrong. She might be appointed as a headmaster in some other school.
Maybe even she doesn't have a claim, I also doesn't have a claim. So unless that is the now, what will be the thing, Lordship? Just for understanding myself, Lordship. I am holding the in charge post. Her appointment to Berkeley High School is not set aside. She will continue to claim that position, and by that time, what will happen to me, Lordship? Till selection committee holds a new interview, they consider the ACRs. What will be my status, Lordship? Where will I go?
You are otherwise now the assistant teacher or in charge. In charge is gone.
Assistant, both are assistant teachers.
Now you are in charge.
In charge. Unless that is protected, Lordship, till consideration by the selection committee, where will I go, Lordship? Because the appointment of respondent 7 stands. In spite of your Lordship holding.
So, but till the exercise is done, you will be in charge principal.
Well, this will be, my lord, against the principle of the selection. I have been selected, rightly or wrongly, whatever your lordship has observed in the judgment. His only claim is confined to Borkola High School, which he cannot. He doesn't have any vested right to continue in the Borkola High School as the headmaster. Because district, let me complete. I have derived the right from the authority, my lord. He doesn't have the right as far as this writ petition is concerned. He has filed the writ petition challenging my appointment, he being the senior. If I may take a lordship to page 47, there are other junior members.
That's what I'm saying. It's okay.
My position as a headmaster, as per the my lord selection list, should not be interfered, should not be hampered, my lord. I am not receiving the salary also. I've been waiting for my salary to be released. He is the DDO. Disbursing authority, he is the disbursing authority.
Wait, both of you are talking. I'm not able to think over anything. I'll think over and give some directions. Okay. I know you'll go for
my
appeal.
position as a headmaster, as per the select list, should not be, my lord, disturbed, my lord. I should
But
be.
as of now, you are not the headmaster. She is in charge.
Because of the status quo order.
Because of the status quo order.
Because anyway, your lordship is not deciding against the respondent number 7. So my position as per the select list should continue. And there is an appointment order also as per the selection list. There is an order reflecting at page 50 of my affidavit in opposition.
Yes, so now the distribution is made promotion.
Wherever he gets his promotion as headmaster, I have no objection. So far as my position as a headmaster is concerned, it should not be disturbed, my lord.
Okay, I said I'll think over it.
Why he is after me?
Petition is disposed of. Maybe at a line I'll say before. I the interim order to any likhit I'll think over. I is for what?
For vacating the status quo order.
Oh, you have filed.
Yes.
I, as in view of the said order, I stands disposed of. I know the interim order is vacated. Hetu bar mosam kiko. Huh? Oh, caveat is also discharged.
While re-exercising page 47 of my affidavit in opposition, may be seen, my lord. The serial number I have mentioned, the date of, my lord, the joining of the incumbents who have been selected. They are in the year 2013.
So they have joined, you could not join because of the interim.
Because of the status quo.
It's okay.
I will be allowed to join, my lord.
Things have gone into, I'll do whatever is
required. Multiple number of petitioners, lordship. Then subsequently equal number of appointees who have been selected are to be considered, lordship.
And in fact, I have joined.
Petitioner is there, and just next, the respondent number 7 is there. So that only will come into, suppose it push back, the entire list push back.
It's okay, argument's over. It's okay, argument's
But
over.
I have already joined page 49, your lordship will consider.
You have not joined. You
I
are
have joined,
still-
my lord, before the inspector of school.
Based on status.
Because
quo,
of the
it
status
states
quo order, my lord, he is not releasing
In
his. further
affidavit,
post.
in affidavit, respondent BTC has already stated that I am holding the charge headmaster also.
Okay, I'll think of. Yes, next. Mr. Chaudhary's matter. Yes. Yes, Mr. Gogoi is not there. Gogoi is missing. Anyway, he's a busy advocate, so. Okay, Miss Kumar, can you call Mr. Gogoi?
Holding court number 1, that item has, is just over.
Yes?
Mr. Gugoi was in court number 1.
Oh.
And that matter has now just been over, so he'll be coming anymore.
Acha, he must be on his way.
Now, my lord, if I had the occasion to go through the instructions, your lordship's attention to some.
So the instructions are like, hold the exam and then.
My lord, what I want to point out, if your lordship comes to.
Eh, okon fan kon diyo kono gom.
Space.
Which page? Instruction. He took it back to make photostat copies. Yes. Acha, anyways, I remember. Tell me.
Point out that in my writ petition, if your lordship kindly comes to page 131, that will be my lord, the first order that I have impugned by which the exam has been cancelled. That date is important, my lord.
131.
131.
Yes, yes.
If your lordship knows the date, that is 24th of February 2026. Now, my lord, in the instructions, your lordship will find that the university has requested the National Commission for Homeopathy to consider, my lord, favorably. That letter is of, my lord, 17/4/2026.
Where is this?
In the instruction.
In the instructions.
Please, this copy. Nice. Instruction to be.
Do you have? No, it's with
Mr.
Gogoi.
B. Gogoi, he's on legs in court number 10, your lordship.
Code number 10.
Yes, your lordship. He'll be here.
So from 1, he has come to 10 perhaps.
Yes, your lordship. The part third matter, your lordship. He'll be here, your lordship. Please.
Then what to do?
Oh,
I say so. Yes. You are required in each and every court.
Facing the file, ma'am.
Acha.
But here, my lord, I have sought for the instructions. Lordship will see the chart, my lord, there. There's
In
one-
your instructions.
Yeah, that chart lordship is holding. There we have already requested the, my lord, council or the board, my lord, to, my lord, relax it on humanitarian ground. They have rejected. So, my lord, this perhaps will not help.
no, that is not the fact.
So let them come, they have party here in, my lord, in the writ petition. So rest I leave it to your lordships.
Who will have to come?
My lord, that particular board, my lord.
No, my lord, what I am pointing out, my lord, if your lordship takes up the last page of the instructions, my lord, your lordship will find the date. This is a letter.
17/4.
My lord.
Yes.
This is a letter by which, my lord, the council was requested that a lenient view has to be taken. That letter is subsequent to the matter of cancellation. Already the examination has been cancelled in February. In April, my lord, they write that on humanitarian grounds they should be considered. So, my lord, in the first instruction, your lordship will find that because you have already cancelled it, so we approve your decision. That is the council. Therefore, my lord, the fault is with the university, not with the council. So, university has to explain in any case, my lord, they are
Yes,
going
we'll have to
consider-
file a affidavit, but, my lord, against those officers. My lord, we have already, they have been suspended, some DP has been initiated or proposing to be initiated. That action we have taken.
Why they have conducted the
Yes, my lord,
examination
that-
before?
Apparently, yes, my lord, in violation of the regulation for.
Okay, they will be penalized, but what about the students?
That, my lord, of course, lordship will have to today.
What I submit,
Yeah.
my lord, perhaps one of my learned friend would also agree, my lord, we have to be reasonable. But your lordship may ask them to file affidavit. In the meantime, let us continue in the, my lord, that is what he submitted. Let us
Internship.
Continue our internship. And let them, my lord, have the instruction or file the affidavit, my lord. More particularly the university.
As well as respondent 3 and 4, my lord. Finally, that relaxation will have to be, my lord, granted by them. They are a party herein, my lord, notice may be issued, let them come, my lord. Or the central
council.
government can, my lord, central government council can, my lord, perhaps accept notice on.
The council.
Yes.
The council is arrayed as a respondent.
Respondent number 2 and 3. 3 and 4.
Acha, National Commission for Homeopathy.
He can appear, my lord. It will expedite the issue, my lord.
Yes.
4 and 3 and 4.
Let the petition remain pending, my lord. Let them come with the affidavit. In the meantime, let us continue in the matter of internship.
But again, continuing with the internship, you'll have some people will finish their internship because 2 months left. So the affidavit won't be filed before 1 month or so.
My lord, here, my lord, one thing, my lord.
Again,
here-
your rights will keep increasing.
No, Lord's, what I'm saying is, my lord, so far as the present writ petition are concerned, my lord, Lordship will see the chart, my lord, in my instruction.
Hmm.
There are total, my lord, 18 persons, my lord, only 6 has appeared. Now, Lordship will kindly see 5, no,
5.
6, 5.
Oh, these are also on the same boat.
Yes, so
These
Lordship
people?
will only protect, my lord, these 5. Others are, my lord, they are ready to appear. That's a different issue, my lord. And Lordship will see the tenure of their, my lord, term. Petitioner herein, my lord, that gap period is of about 5 months, 16 days, 15 days or so. There are persons, my lord, or candidates who have only completed 1 month, my lord.
Hmm. So, okay, 1 month, okay,
They
nothing
are not
much.
before this honorable court.
Not much
The
harm.
action should be only, my lord.
It should be confined to, my lord, the petition. This is right.
But then again, they will continue with the internship and then dismissing the matter will be difficult. Right? They will have more rights by then.
But they are
As
still-
sooner as
Oh,
better.
Yes, sooner the better, my lord. Lordship will give us 10 days, at least university can file it. Within 7 days, we can file it, my lord.
Okay, you also file, Mr. SK Mehdi. He is yet to know the facts and all.
We are applying for a ministry, madam. Here, madam, the National Commission of Homeopathy, madam. Chairman is there, madam. And chairman on the board, madam. So there may be separate council, madam.
Central government appear more, MMC can appear.
But then see, your instruction, there is nothing to keep it pending. Your instruction says that the council has rejected. Your
Lordship
instruction
can
says,
direct, my lord, for reconsideration, my lord. We can move a proposal again, my lord, along with honorable court's order.
consideration, they will consider and again reject.
That I leave it to- But to decide,
Because
my lord,
you have sent it, they have rejected.
Lordship. But my lord, to decide without the affidavit again, my lord, will be something, to give a final order, mandamus, my lord, to that effect. Today itself. So short date, my lord, so far as the university part, my lord, I will file my affidavit by next week, my lord.
Let there be short date, my lord. We will also take.
Okay, heard Mr. M.K. Chaudhary, Learned Senior Counsel assisted by Mr. Bharadwaj, P. Bharadwaj, Learned Counsel for the Petitioner, and Mr. B. Gogoi, Learned Standing Counsel for Health. And
No,
no,
you
right?
have-
You are not.
Including the university, I can appear, my lord.
Representing,
1, 2, and 5.
representing respondent number 1, 2, and 5.
5, my lord, 6, 7. as well as
6, 7 also?
Yes.
1 to 5 to 7. As far as a National Commission for Homeopathy, New Delhi, Mr. SK Mehdi, you can appear. Hmm.
Send, madam. I'll send.
Huh?
I'll send a copy, madam.
But Homeopathy Education Board, again, board,
Board, my lord. he will-
Registrar Board of Homeopathy.
My lord, that they can, perhaps, my lord, Dusty
Notice.
service, my lord, to respond number 8, at least the board will know in that case, my lord.
Yes,
He's in Gauhati. They
He's
can
in
take
Gauhati.
Dusty service.
Eight is the system.
So, okay, serve notice on 8. 8 will inform 3 and 4. Right.
Yes, it will be more.
This is an application by which the petitioners have challenged the cancellation of the 4th examination. What do I say? I don't know the terms, no? But
BHMS.
where is it? Show me the impugned order which, yes, I've got it.
131, my lord.
Have challenged the notice dated 24/2/2026 by which the 4th BHMS examination held in April 2025 was declared as null and void for those students. Was declared as null and void by the university. By what university? What? By Srimanto Sankardeva University of Health Sciences. Stop. They said cancellation is made due to the fact that the examination of fourth BHMS that the fourth nalaga examination that the fourth BHMS examination was held before completion of 6 months from the date of holding of the third BHMS examination, as it is provided under the rules or notification, or provided under the regulation that there has to be a 6 months gap between two examinations. It is stated by learned senior counsel that petitioners have not only successfully appeared in fourth BHMS examination, but they are continuing in their internship. What in their internship?
Compulsory internship for 1 year.
They are doing their internship of 1 year conducted by the university. And he further states that 2 of the candidates have only 2 months left for completing the internship, and the other 3 petitioners have 6 months left for its completion. And the Learners' Council as such submits that there is no fault on the part of the petitioners for which they are made to suffer. It is the fault of the university who had held the examinations before completion of the mandatory period after the previous examination. He further submits that there is a clause in the regulation for condoning such incorrect. Where is that condoning thing? Page? Incorrect. Relaxing there, huh? Relaxing. কি বলি কলো? He further states.
In the regulation.
Clause, that is clause 14.1. You say section or clause? Clauses. It is a regulation. Clause 14, subclause 3, which provides that a university or medical institution may relax the requirement of any provision of the said regulation in a case that is just and proper. As such, he submits that the gap between the examination of the gap between the third examination and fourth examination was only for 5 months 15 days, was only of 5 months 15 days, and that only 15 days had to go to complete the term of 6 months before holding the next examination.
For appearing in the fourth year examination.
For appearing in the 4th year examination. He as such submits that that 15 days period, that short of 15 days period can be relaxed by taking recourse to the said clause, for which the students will not suffer. Mr. B. Gogoi, Learned Standing Counsel for Health, has however placed an instructions which shows that the university had recommended for relaxation.
Yes, my lord. In fact, the Sankardev University, my lord, by the communication dated lordship, is there in the buns.
By
17/4/2026.
Which date?
17/4/2000. My lord, where there is a chart, my lord.
Yes, this the one I'm only. 17/4/2026, right?
Yes.
He submits that the university, the registrar of the university, by letter dated 17/4/2026, had written to the chairperson of National Commission for Homeopathy to kindly consider the case of the students on humanitarian and academic ground. But the council had rejected the said request. By letter dated 19/5. Yes, Gogoi?
Hello?
19/5,
Yes, sir.
2026. In view of the same, Mr. Gogoi makes a prayer to allow him to file an affidavit, bringing into records the subsequent development as well as the other facts, and has prayed for some time. Prayer is allowed? For the benefit of the students, it is, however, directed that the petitioners be allowed to continue for their internship, may be allowed to continue doing their internship for the time being. Right, that would do for the time being. Without Rekika, without making them to appear in the examinations which are scheduled to be held in the month of June 2026.
Now regarding steps, you will say.
Mm-hmm.
Regarding the steps that.
Further? Oh, issue notice. Notice is not issued, right? No, instructions only. Issue notice to the respondents. Mr. B. Gogoi, Learned Counsel appears for respondent number
1 to 5 to
1, 2, 5,
6,
6, and 7. Petitioner to take steps for service of notice upon respondent number 8, who in turn is directed to inform respondent number 2 and 3 in their offices at New Delhi.
3 and 4.
Oh, 3 and 4, huh? In their offices at New Delhi. List this matter again on by speed post with AD or by usual process or by Dusty.
Let it be Dusty. So far 8 is concerned.
Okay, by Dusty Koidia. And the petitioner is at liberty to file an affidavit showing the said service. List this matter again on. You bring it within a short period because I have extended the internship.
That's it.
So you bring it by 1st of June.
Minor, I will file it.
By 1st of June, okay? And try to inform the council as well. You also.
Yes.
Because even if they file their affidavit by 1st, then the matter can be settled.
Madam, the university will on their own do that, madam. At least mail, but through mail or something.
For the
Lordship will give a date, madam, after first.
list on 1st of June?
Yes, we will file it by then.
By then. By which date? The respondents would file their affidavit? Okay, file their affidavit first.
One prayer, my lord, that they will continue in their internship along with their stipend, my lord, that what may be added.
If you do your internship, you'll definitely get your stipend is stopped.
Prayer is there, ma'am.
Along with their stipends. It was not their fault. Okay. Yes.
That is a bucket. Well, the item number 1, the.
Affidavits are exchanged.
Yes, my lord.
Ready for hearing.
Yes, my lord. The honorable court on the last occasion passed the order that today it will be considered for the interim review.
Interim.
Yes.
Why not
That
full?
yes, in view of the affidavit which has come, my lord.
We have not filed affidavit in opposition, my lord.
Hmm.
The one question raised by learned senior friend, my lord, regarding the jurisdiction of the issuing, my lord's search sheet, my lord.
Uh-huh. Jurisdiction?
Yes,
My
my
lord,
lord.
let me just explain it.
Hmm.
That the petitioner is a deputy registrar in the respondent university.
Ha.
Petitioner is a deputy registrar in the respondent.
Deputy registrar.
Yes.
Okay.
Now, there is one charge sheet issued against him, and which is in challenge in the item number 1. And there is an order of suspension continuing against him, which is in challenge in item number 2.
Hmm.
Now, the general ground in both the cases is that the person who has issued the charge sheet and the person who has issued the memorandum of charge, he does not have the authority to act as my disciplinary authority.
Acha.
And therefore, I say that the charge sheet should go and the suspension order should also go.
Hmm.
So that is the ambit of the issue in the
Charge sheet is otherwise a different procedure.
No,
Charge sheet is after a FIR is filed.
no,
Oh,
no, it's a disciplinary proceeding.
oh, acha.
It's a
Charges.
it's a departmental proceeding. So I say that the person who has issued the charge sheet, he does not have the authority to act as my disciplinary authority. And the same person has placed me under suspension. So I say that he also does not have the power.
Hmm.
Now that is the ambit of the issue in both the writ petitions.
Hmm.
Now here comes the response from the respondent, quoting several provisions of the act, because it's an university constituted under an act.
Hmm.
And the powers of the authority.
Private university.
State
government.
State
Hmm.
government.
Hmm.
Now the power, since it's a statutory university, creation of statute, the mode of conduct of the business of the university and the regulations, etc., are all have to be guided under the statute.
Hmm.
That is the act.
Hmm.
Lord, my submission in a nutshell is that, my lord, the act is the grand norm for all actions
Hmm.
that the authorities may conceivably take in the matter.
Hmm.
Now, our case is that in both the particular cases, it is the respondent number 4 who happens to hold the charge of the registrar of the university, who has issued the charge sheet and who has placed me under suspension. I say that the registrar is not the authority.
So the appointing authority has to do it.
Exactly.
Hmm.
Now,
He is not the appointing authority.
no, registrar is not the appointing authority. Now, they want to say by filing the affidavit that registrar has been authorized by the executive council, and it is because of the authorization by the executive council that the respondent number 4 has the memorandum. Yes.
Delegated.
That is their case. That is
Delegated means
Not delegation, my lord. I'll place. my lord.
authorized.
authorized.
I'll place, my lord.
Authorized. So, my lord, I am obliged that it has fallen from your lordship. If it has to be by the authorization of the executive council, naturally executive council must have some power of delegation.
Hmm.
In absence of delegation, they cannot act.
Hmm.
Now I'll take just your lordship to the act.
Hmm.
The act speaks of delegation of powers of only the vice chancellor and the registrar.
Hmm.
It does not speak of delegation of power of any other authorities.
Hmm.
So therefore,
Hmm.
my case is that since the act does not provide for this, your taking a resolution or authorizing somebody, these are non-esteemed law.
Hmm.
That is my case in both the petitions.
Hmm.
He has his basic case, my lord. He can take your lordship through the pages of his affidavit, my lord. The basic case is that there is an authorization, there is a resolution by the executive council, and the executive council has authorized him to issue the charge sheet and also to place me under suspension.
If he does not have the delegation powers,
Yes.
how can he do
Now,
it?
if your lordship-
He'll authorize somebody to do something that cannot be
I'll
done.
place, my lord.
Now, your
If-
lordship
if-
will kindly see, my lord, the copy of the act on the previous day I had supplied to the brief lordship. In this act, your lordship will find, I'll take your lordship straightway to delegation.
Wait, oh yes, I have the act.
Yes,
Rabindranath Tagore University Act.
Yes, yes.
Hmm.
there in page 4798.
47? Hmm.
4798 is the only provision in the act.
Hmm.
I would be obliged if my learned friend can point out any existence of any other thing.
Hmm.
This section 54 says
Hmm.
about delegation of power.
Hmm.
And as I submitted before your lordship, this delegation is only with regard to the power of vice chancellor and the registrar.
Vice Chancellor with the previous approval of the Vice Chancellor, the registrar.
Subject to the
delegate
provision
of-
of the
Vice Chancellor, some provisions of this act, the Vice Chancellor and with the previous approval of the Vice Chancellor, the registrar may delegate his powers.
So here is a case where registrar has authorized.
No, Executive Council has authorized the registrar.
Oh.
Now, where from do you derive the power? Any act that you do in a statutory, ambit, the power must be given somewhere in the statute.
So the registrar could have exercised the power on the approval by the Vice Chancellor.
Now the question is, the Vice
Lordship
Chancellor
allow,
is not
if
the
Lordship
appointing
allow, I'll
authority.
place, my lord, my.
Vice Chancellor is not the.
No.
Yes.
The appointing authority is
Is
the
the
Executive Council. Now,
Executive.
if the Executive Council wants to take some decision against me, placement of suspension or they can do perhaps, my lord, although I'll say, my lord, that there is no express provision in the act which authorizes the Executive Council, because the act says that after commencement of the act, the Executive Council shall frame the regulations to regulate the terms and conditions of the service of the teachers and employees. No regulations have been framed. By a simple resolution adopted by the Executive Council, they have said that we adopt the provisions of the Assam Services Discipline and Appeal Rules, and under the provisions of those rules, disciplinary proceedings will be conducted. Now, the Service Rules 1964 conceives of various powers of disciplinary authority, then appellate authority, then revisional authority. Even if you adopt something, then as per the provisions of the act, it says that the thing should go to the Senate, which is in their terminology, they have said it court. It should go to the Senate for ratification and approval, and then only will derive the statutory power, otherwise not.
So there are two things. One is that under the University Act, the Executive Council does not have the power to delegate
No,
to anybody.
no.
In this case, Executive Council has authorized the registrar to pass the order, and registrar has issued the
No, that is wrong, my lord, the wrong submission.
That is his
No,
affidavit,
my
my
lord.
lord.
Then
I'll-
if Lordship,
Let him complete,
yes,
then I'll come
yes,
back to you.
yes.
That is his affidavit. my lord. In his affidavit, he has enclosed two resolutions, and by showing those resolutions, he wants to say that these are the resolutions by which the registrar has been empowered to issue the suspension order. My lord, without spending much of time, I'll just take your lordship to the resolution that he has filed. Your lordship will kindly take up his affidavit. In his affidavit, my lord, the resolution will appear at page 254. Sorry, 200, yes. The first is, first resolution is at page 254.
254.
Yes.
There is no page number 254 here. 219 is the
My lord,
last.
in my affidavit, man.
His affidavit.
His affidavit is where?
I see item.
Malab, it was filed on 19th May. Tomorrow morning, this morning, he made a requisition to call for that record.
Oh, acha. So it will be here somewhere. So affidavit by the
By the university.
Response number 2.
Yes. Kindly see page 254.
Yes.
Now, in page 64, under the heading resolution number so-and-so dated 25th February 2026. Now, the House unanimously resolved that the inquiry into the matter should continue by putting so-and-so under suspension as the departmental proceeding is contemplated strictly in accordance with the provisions of so-and-so maintained. Now, this is the resolution authorizing the registrar. That is his affidavit. Now, on the
So this resolution was taken by the Executive Council.
Yes, ma'am.
he says so, my lord. Although I have doubt about this, my lord, he says so. So I take his word that this is the resolution.
So the
if-
resolution number 3.
Yes.
Resolution number 3 of the special 19th Executive Council meeting of so-and-so university held on so-and-so under the chairmanship of Vice Chancellor.
Yes.
Okay.
So
So
he says
resolution
that
is
this the
taken.
source. Now, if this is the source, then where is the power of delegation? Executive Council must have a power of delegation. Then only the question of delegating come. This is one limb of the argument.
Maybe Executive Council is the appointing authority,
Yes.
but they have not done it.
They have not.
They have authorized the registrar to do it
Yes.
without there being any power.
Without there being any power. This is number one. So my submission is that the grand norm in the case is the act. Now, act provides for the mechanism as to how the university will function and as to how the authorities they are under will react to these situations. Now, if you are delegating some of your powers,
then there must be some corresponding provision in the act. Otherwise, the delegation is non.
So delegated power is only with
With the vice chancellor.
Vice Chancellor and with the approval of the Vice Chancellor Registrar.
Registrar can delegate his powers, not the power of the Executive Council.
Yes, his power.
His power. So in none of the case, my lord, neither the Vice Chancellor is my appointing authority, nor the Registrar. So how do you act? This is my first submission. Second submission, my lord, assuming for a moment that they can act, although it is not so, even if you apply the provision of the Discipline and Appeal Rule 64, then there are 2-3 numbers of authorities described therein. Who are the authorities in the case? Of the Senate, it does not get the statutory character.
But okay, we consider they have approved. They have adopted.
Even if it is so, then where is the, because why I am saying so, because if your lordship will kindly come back to page 4782.
4782.
Yes.
No page number or what?
In the act, my lord. In the act, your lordship will find the powers and duties of the court. Court means the Senate of the university. Senate of the university.
Wait. Powers and duties of the court.
Yes. That is Senate of the university 25.
Senate of the university would include who?
My lord, this is the Senate. On the previous page, your lordship will find at section 22, the authorities are described, and section 23 says about the court. And court will comprise of the, there are 21 officers named there. Now, the powers and duties of the court is explained in 25, and your lordship will find 25(3). To approve with or without modification the statute submitted by the Executive Council. Now, under the provisions of the Act, the Executive Council is entrusted to formulate the statute. Now, you formulate the statute, file it before the council approves it, the court approves it, then it assumes the statutory character. Otherwise not. I don't know whether who has been advising them to do it in such a bizarre manner that Executive Council sits somewhere at their sweet will, they adopt certain things.
Who adopted 1964 rules?
1964 rules, if your lordship will kindly have it.
Executive Council, man. EC adopted.
Executive Council.
Now, 1964 rules visualizes at least, my lord, 3 authorities. One is appellate, disciplinary authority, one is appointing authority, and one is appellate authority. Now, you say that you have adopted these rules. Necessarily, therefore, you are to prescribe as to who is the appointing authority, who is the disciplinary authority, or who is the appellate authority. Nothing has been done. That is the basic case. It's a case, my lord, where out and out, my lord, it's an exercise of jurisdiction which is not vested in law. That's my case.
Yes.
Now,
I've
if your
understood
lordship will just bear with me for a moment. I'll just, in the same compilation of the statute, the lordship will find page 4796, the regulations. Section 49.
Yes.
Subject to the provisions of this act, statutes and ordinances, each of the authorities of the university may make regulations consistent with the act, the statutes and the ordinances for the purpose of carrying out the duties and for exercising the powers assigned to the authority concerned under this act, statute and ordinances. So therefore, the requirement is that if you want to carry out any of the exercises which is conceivable as to be possessing in you, you must necessarily bring a regulation or a statute or an ordinance as the case may be. Where is that?
So the registrar could have done it, could have taken recourse.
If at all it could have been done, it ought to have been done by the EC. Then EC ought to have formulated the regulation, forwarded it for approval by the Senate, ratification, then only the statutory character comes.
Regulation will come into effect.
Then only the regulation will come into effect. In a void, you cannot just simply say that, no, today I decide. And who is this person? He is a person who is probationer, who is not even appointed permanently to any post. The entire idea is that, my lord, I am not taking your lordship to the history because there was also a past litigation. The entire idea is to harass me.
No, my lord, it was withdrawn by himself. Withdrawn, my lord.
Their entire idea is there was a notification for the appointment to the post of registrar. Some anomalies were noticed by me. I made a challenge to the court. Initially, the court granted me an order of status quo. Now,
You are a
I'm a
professor.
deputy registrar.
I'm a deputy registrar, yes.
There was a appointment process for the appointment to the post of registrar. Some anomalies were noticed by me. I came to court, the honorable court granted me an order of status quo. Now, as long as the matter were pending, simultaneously they came up with this noble idea of putting me under some suspension and the protracted disciplinary proceeding. And kindly see, very interestingly,
So the appointment of registrar was challenged.
no, the appointment process was challenged.
Acha.
Appointment process was challenged because I said that by expanding the date of last date of submission of application, they were trying to induct some persons who were not eligible.
Well, everything is wrong, my lord.
So that was the
From
that was
record,
the
my lord,
challenge.
from
in the-
record. Yes, ma'am.
I'll come to you.
So that was the challenge in the writ petition. And after I got an order of status quo, hurriedly they did some exercise. They brought these gentlemen, who is respondent number 4. They brought these gentlemen. I was holding the charge of the registrar. They relieved me from the charge of the registrar, brought these gentlemen on temporary basis to hold the post. And thereafter, this series of things have happened.
So during the period where the status quo order was valid, they did all this.
My
They
lord,
brought another person and appointed.
No,
that-
my lord, just a minute. Why are you so anxious about
my
it?
lord,
See, you sit now, you have your seat, you'll
chance,
get
or
your
you want
turn.
to argue first?
yes, ma'am,
Hmm.
yes, ma'am.
My lord, I moved the writ petition on 24th of November.
Hmm.
The order of status quo was passed. 25th November, well, since they have a standing counsel, well, they get prior information. 25th of November, they relieved me of the
Registrar.
post of registrar,
In charge registered.
in charge registrar. They could not have done it without approval of the executive council. So what they did, they took post facto approval of the
Oh.
thing. Now, anyway, my lord, I had to withdraw that writ petition because of the circumstances, because by that, soon thereafter, the show cause notice came. So I preferred that I would withdraw the writ petition, and if necessary, I'll file afresh. That was the idea. Now, they gave me a show cause, I replied. Now, after getting the reply, these developments come, they put me under suspension and initiate a disciplinary proceeding against me. Now, your lordship, as I have said, I have shown to your lordship, my lord,
Hmm.
this, if your lordship will again come back to, and kindly see their vigilant effort, if your lordship will kindly take the resolution at page 254 once again. They somehow want to obstruct me from going into the university or pursuing my career there.
Hmm.
And kindly see the first agenda number 3.
Hmm.
The Honorable Vice Chancellor informed the House that approximately 2 lakhs has been spent in connection with both the cases.
Hmm.
So this is the effort they are paying. Why?
My lord,
They want to-
what connection with his case, my lord?
To whose resolution? This is your affidavit.
Yes,
I'm not
yes,
reading anything
yes,
from my pocket.
Maybe.
Mr. Midhi, you take your seat.
I understand, but.
So-
You take
so-
your seat,
so
otherwise
this is
things
the-
will go bad.
So this is the effort they are making.
Hmm.
The entire idea is so that I cannot go to the post of registrar.
Hmm.
But I am not on those aspects because of the fact that my challenge is limited to the competence, legal competence of the authority. Now, legal competence of the authority, I have shown to your lordship the basis. This is their basis. They say that this is the resolution. Now, even if you make a resolution, you go on making resolution. Who cares? Ultimately, it has to be guided through the process as the prescribed.
No, as far as your argument goes, that he doesn't have the power, that okay, I've understood.
Yeah.
But what about 1964 rules?
No, they have said that we have adopted the 1964 rules. Now,
By adopting, what will happen?
nothing.
Huh?
Nothing. Your resolution has to be ratified by the Senate. Because the power of the court, I have read out to your lordship. The power is vested because it's a statutory prescription.
No, under the Act, only 2 authorities to have delegation power, delegated power. So they are not there.
They are not there.
So they cannot pass such orders.
No.
Right. So the council cannot authorize the registrar to pass any order.
Yes.
And registrar has issued the charge sheet, issued the
Based on
suspension.
the resolution of the EC.
Based on the resolution of the EC.
Now, this
That also-
resolution is without any effect.
This resolution is what resolved that the inquiry into the matter should continue by putting so and so under suspension. Resolution of putting him under suspension, and after that, registrar had issued suspension order.
Yes.
After this
Yes, it is
resolution.
25th. and 26th, the suspension order comes.
This is 25th.
Yes,
This is dated, yes, 25th.
25th. And
So-
26th, the suspension order comes.
And charges were,
Charges
memo
were-
of charges.
Charges were framed on 24th of March. In the first writ petition 2411, the Lordship will find the charge sheet at page 74.
Charge sheet means charges frame, charges, memo of charge.
Memo of charge,
So memo of charge was served upon the petitioner when?
24th of March.
24th of March.
Yes,
After this.
after this. And there, interestingly, there the respondent number styles himself as the disciplinary authority.
The registrar.
Yes, here I'll just read out page 74 to your Lordship.
So registrar cannot be the disciplinary authority.
No.
So at best, executive council can.
At
He is the
best.
appointing authority.
At
No,
the
no,
most.
you take a seat, I'll come back to it.
At the most,
Again, you'll make the atmosphere very serious.
at
Hmm.
the most,
Hmm.
subject to having the procedure set in place by following the prescription of law, at best, it is the executive council.
Hmm.
Now, page 74, your Lordship will find registrar in charge proposes to hold a disciplinary proceeding. What is your authority?
74.
74 of 2411, writ petition 2411.
Writ petition 2411. Right?
Yes.
The registrar.
Yes, registrar so-and-so university proposes to hold a departmental proceeding.
Hmm.
Where from you derive this power?
Okay. Okay, fine. So these are the 2 points that you want to.
And in the other writ petition, the suspension order is under challenge,
That is also by the registrar,
also by the registrar.
which cannot be done by virtue of that resolution.
Yes.
Okay, so what do you have to say?
Actually, my lord, the things have been done in such a
Hmm.
just to stop me, as I said, that is the background story, my lord, to compete against the post of registrar. And when you do something in a hurry, you miss so many points. That's why I said, my lord, I do not know who has been advising them. At least the act has to be looked into. There are ordinances passed by the university that has to be looked into. There are statutes passed by the university that also has to be looked into. You take into consideration now. And interestingly, although the university has placed the first resolution in its entirety, this page 54 is only an extract. Therefore, I have reason to doubt whether this is the exact resolution or.
So what about agenda 1, 2?
Nothing is.
We have, my lord, we have, my lord, so required.
So, my lord, I am not going into the genuineness of the resolution. My plain and simple submission is that even if the resolution be true and correct, it cannot have the force of law. Because the act says otherwise.
Okay.
That is my case. So, my lord, if he wishes to file a detailed response to the writ petition, my lord, I would humbly submit that your lordship will kindly pass an interim order in my favor. Or if he wishes that with these materials, your lordship would dispose of the writ petition, my lord, sooner the better.
My lord, so far all these pleadings.
Now, first of all, you say whether this affidavit would be sufficient or.
Oh, no, man, only my lord, under jurisdiction point last occasion, directed we filed, man. Only their writ petition, only one pleading is there, my lord, I'm reading, my lord, page 11, my lord. The petitioner state that the issuance of the memorandum of charges by the respondent.
Page?
Page 11 of the writ petition, man.
Yes, of the
It-
pleadings.
By the respondent for is illegal and without jurisdiction. For he cannot act and disciplinary authority of the petitioner. On this ground alone, memorandum of charge dated so and so is liable to be interpreted. That apart, the impugned memorandum charge will suffer various allegation level therein and contradictory, hence cannot be understood considered misconduct. The memorandum charges dated so and so they are liable to set aside and all action taken
Okay.
on the basis thereof
Yes.
are liable. This must, my lord, he is the pleading, my lord. This must pleading. What about the now submitted the regarding?
He has challenged the memo of charge, saying that the.
Yes, my lord, so far this 1964 act, all these things, adoption, this was, there is no pleading, my lord. This, that part.
These are just law points.
Yes,
His
yes,
main
yes.
pleading is this only, main prayer.
I'm coming on this, my lord. Here, my lordship may turn, my lord, I'm from this, from my affidavit page to 2 to 9, my lord.
Yes. No, if you want to file a detailed affidavit, let me know.
But no interim order, my lord. Because my lord,
This is
this
very interesting.
allegation is very serious, my lord. Lordship,
So you'll have to file it within a week, then I'll not give.
yes, my lord.
Well, we'll take up the entire matter.
Yes, my lord. Yes.
Well, in that case, well, I would say, if you're, that will amount to vesting some authority in the respondents, which they do not possess.
My
If-
lord,
if-
my lord,
if your
my lord,
lordship is convinced
I may submit, my lord.
that-
My lord, this, if lordship, go through the memorandum of charges, my lord. Even my lord, what initially he applied for deputy registrar, my lord. At that time, his only LLM degree was there, my lord. And my lord, that application, my lord, when he was in charge register, my lord, he ordered his the staff, office staff to give the application, and he took back, my lord.
So
It was-
these
it
were
was not-
memo of charges.
Yes, my lord, it's serious, and his, my lord, LLM degree is not valid, my lord. This is an online degree, my lord. If that ground his service, my lord, we can dismiss, my lord, because online LLM and Bar Council of India says, my lord, it is not valid as per Supreme Court judgment. my
Okay,
lord.
those will be
My
seen,
lord,
but
whatever my senior submit, my lord, everything is as if the university, this is university, my lord, state university. We have stated maybe something wrong, but may not be admitted, my lord. But this reader only that person, that person was dismissed in earlier service. He was a sub-inspector of the police, my lord. He was dismissed from the,
Petitioner.
yes, my lord. And the
Okay,
subsequent review of
he
it.
can have many
background,
charges
lord,
against him.
even RTI,
That means even
RTI
if I was a
information was given,
sub-inspector,
my
I
lord.
cannot pursue further
My lord,
steps.
RTI application given, my lord, there is no such RTI application, there is no some postal stamp, there is no such postal,
Okay,
everything
okay.
is there.
This
That man
will
might
come-
say to
this
allegation
will-
against us, my lord.
This will come only after you are properly authorized to give those memo of
I'll
charges.
submit, my lord, I'll submit, no doubt. My lord, his appointment was given, now, when he's appointed, this page 229, my lord, 229, it was by the insert register. Insert register, this appointment was issued, my lord.
Yes, when he was.
And thereafter, he joined before the insert register. And my lord, advertisement also issued. by the
Okay, you file your,
register.
don't take it personally,
Yes,
it's
no,
okay.
I'm not personally, just
Acha.
I.
So,
Now, one factual correction I need to make, my lord. My learned friend says that when I had applied for the post, I was holding only LLM degree. That is not correct.
My lord,
I
it was subsequently this, that they made, my lord. This is subsequently, this,
I
we have scrutiny committee report, my lord. We
lordship-
supplied, my lord, at the only the LLM thing. Subsequently, all these things is prepared, my lord.
Your
This
lordship
type of
will
man,
kindly
this, my lord,
see-
is a client is my
Your
lord.
lordship will kindly see
lord, I
page
don't-
178. I was possessing the degree of doctorate in law.
My lord was subsequently.
it's okay. So you file your affidavit.
Yes.
In the meantime, don't initiate any
No, no,
departmental
so
proceeding.
So that is already underway, my lord. That's why I'm asking that it should
I'm
be stayed.
assuring, my lord, on the direction of this honorable Lord, he actually, not filed the so-called reply also, my lord. This honorable court directed to file the so-called reply on 15th of this month, he filed the so-called reply, my lord. So,
There is one order, wait, what happened to the last order?
yes, my lord,
Last
yes,
order, your
yes.
lordship will kindly see para 4. My learned friend is now saying that he will require a detailed affidavit.
My lord,
Kindly
is
see
the
para
this
4.
court, this order, my lord.
Mr. So-and-so submits that he would complete his instructions and file an affidavit in the matter, including on the issue of jurisdiction.
Yes, my lord.
Jurisdiction part you have mentioned in the affidavit?
Yes.
My lord, so far it's I am submitting that his appointment was issued by the insert register.
So when did you file this affidavit?
Yes,
Today?
yes, sir.
Yesterday.
Yesterday.
It was ordered on 8. Now they filed it yesterday.
My lord, yes.
You have gone through the affidavit?
Yes, my lord, there is absolutely nothing, lord. There is absolutely
My
nothing.
lord, day before yesterday,
filed it
last
only
Saturday, they
after
filed
the
additional
process.
affidavit, my lord.
Because they knew that today is the date fixed for interim consideration of interim.
My
relief.
lord,
That was
my
the last
lord,
order.
my lord,
Now they filed the affidavit yesterday, thinking that today it will be delayed.
my lord,
It will
with
be
you,
deferred.
my lord, with due respect to my senior friend, my lord, this, whatever,
I'm
yes.
not anything, I am saying against the university. Kindly
Wait,
see the
he would
university's
complete,
conduct.
wait, I cannot read it, including the issue of jurisdiction of the incumbent in the post of registrar.
Issue the memorandum of
Memo of charges
charges.
raised by, considering the submissions made by the issue of jurisdiction to the issue. Would require detailed consideration. Considering the issues, submit a written statement to the memo of charges honor without prejudice.
So that I have complied with.
Acha, so you have not filed your reply, right?
I filed it. I have filed an additional affidavit, my lord, bringing it.
No reply to your memo
No,
of charge.
because I challenged the jurisdiction, so I that may be constitute that.
So let the,
might be jurisdiction.
let the disciplinary proceeding be stayed for the
No,
time.
my lord, this, I am assured, my lord, nothing will happen, my lord, until next day, from
So
my
if
mouth.
you are assuring me nothing will happen, so what is the problem in staying? with
No,
the
my lord, but still, but stay, my lord, stay.
That means we will continue.
After stay, my lord, there, it will, they will take time and it will continue, my lord. I will assure, my lord, next day.
No, no, that will not
No,
be,
my-
that
no,
will
my-
reflect
no, my-
in the order.
No, my lord.
No, that your lordship make it conditional.
No, my, no, my,
That
no.
No
condition.
adjournment will be
My
stopped.
lord, only next, on 28, may fix for PM, final hearing, my lord, 28, my lord.
28 can be a holiday.
27 is holiday, my lord.
My lord, my
No, no, they can shift to 28.
And then,
Idu Juha must maybe on 28. This is
my lord,
not
my
for sure.
submission is that, my lord, in both the repetitions, my lord, your lordship,
on,
at least
on,
till
on,
the,
on,
till the time you
third,
file the
third,
affidavit.
third, my lord.
Until the next returnable date.
No, my, no, my.
Because see,
no,
the
then-
registrar is not,
My
there is
lord,
no delegated power.
my lord, if lordship pass any order, my lord, then the, my submission, I will be allowed to submit my points, my lord, if there is, because in 10 days, nothing will happen. Matter fix on 3rd of June, my lord, till that, we will not proceed anything, my lord.
So I'll write that undertaking that you have
Yes,
given.
My lord, it's not
yes,
about-
ma'am. Yes, ma'am.
it's not
Undertaking will be
about-
taken.
not simply not proceeding against me. Why should I survive under an order of suspension when
My lord, suspension
absolutely
is,
illegal order has been passed?
no, no, my lord.
When
Suspension,
and-
I have judgment,
and
my
I
lord,
raised the
suspend
jurisdiction before them.
we can send, my lord.
They are not answering it.
We can suspend, my lord.
This is item number what? Can I
Item
take it?
one
for
and
Item
final?
number 1 and 2 is
Oh,
the
oh.
suspension order.
There are so many matters left actually. So I could have taken the hearing.
Because therefore,
On,
my
on
submission is that,
lordship,
my lord, I
your
am not-
lordship, or
I
your
am
lordship
not
may
pressing
fix
your
on.
lordship for final disposal. The lordship will grant them some time if they wish to.
My lord,
respond to
my
the
lord, no, my lord, I have assured, my lord,
Till that
nothing will
date,
happen,
my
my
lord, your
lord.
lordship
No,
may-
my lord, no, my lord.
Lordship may grant an interim.
No, my lord.
Otherwise, why this court would pass?
No,
a-
my lord.
Because it was a previous order.
Just
understanding
show
of
me
the-
one line that you have the power.
My lord,
Registrar.
so, see, I'm coming to my lord affidavit.
Executive Council has
My lord,
a resolution had given you.
my lord, I'm coming, my lord. This, page 229. 229 is the advertisement, my lord.
2 to 9.
Yes, my lord. It was advertised by the incest principal, my lord, this, for this particular post, my lord.
2 to 9.
229 of my affidavit, my lord.
Yes.
231 is the.
This is what? This is the appointment.
Yes, madam. This appointment, he issued.
No, no, I want an answer that whether
let-
registrar has the
let-
power.
Let me go, madam. Then thereafter, my lord, he appointed, he joined also before the register, my lord.
Hmm.
And my lord, his appointment letter is, my lord, page 134, my lord. My lord, page 130, 235, my 235.
Hmm.
You are requested to inform the undersigned within 15 days from the date of issue of the letter, you are, whether you are willing to accept the offer on terms and conditions mentioned above, and when you may accept it to join your duties at the university or
This
may
is
join.
the offer letter,
Yes,
offering.
and my lord, he submitted joining report before the register itself. Register is the member secretary of the executive council. Here also, my lord, the insert register is, my lord. And my lord, power of the register, my lord. Power of the register, I'm going to paste on 237. Register,
See,
my lord.
here the appointing authority is the executive council.
I'm going, my lord, because your lordship is going to
If I'm
pass.
not hearing finally,
No,
then
if even lordship is going to pass an interim order, then
that's okay, we will hear the matter on 26th, next Tuesday.
26.
Can you file your affidavit by then?
Well, they will not file, I know.
No, but we'll file not.
They will not file.
I-
It has been their strategy, my lord.
My
If
lord,
they were
my
so
lord, this
curious
is the
about
way, my lord,
8th of
my senior friend,
If it
senior
has to file
counsel.
his affidavit by 26th, the matter will be taken up for final disposal.
If he agrees thereby, my lord.
Okay, Mr. Mehdi? You have already filed your affidavit,
Your
on 2
lordship will-
pages will
Your
do.
lordship will also kindly.
Yes,
consider
ma'am,
the previous
26,
order of the court.
26, ma'am,
Previous order of the court, my lord, it was on consideration of both the side submission, it was speak, this day is speak for consideration of the interim.
26, my lord.
Now, I do not understand, my lord, if he wants to build up a case beyond his affidavit, my lord, then I don't understand.
My lord, last occasion, they file an additional affidavit, my lord, again, there is new plea without
You
amending.
see,
the petition.
my query is whether the registrar has the power to issue this
Yes,
suspension
yes,
order,
ma'am.
and he is not being
Register
the
is
appoint-
register is a.
Listen to me.
Yes, ma'am.
Otherwise, you go away, I'll not take up, be placed it before appropriate bench. What is this attitude?
My lord,
By showing the appointment orders passed on behalf of the Executive Council by the registrar, what are you trying to show?
yes, my lord, he is the issuance authority, my lord. He is an issuance authority. Here, my lord, status says he is the issuance authority, my lord.
Now, the simple question is, the Executive Council doesn't have the delegated power. And so he could not have delegated to the registrar to issue such
My lord,
memo of charges.
my lord, here, my lord, the registrar is the issuance authority.
Sir, my time is being wasted. You file your detailed affidavit on the jurisdiction point.
Yes, ma'am.
Okay.
Hello.
And on Tuesday. And if he does not file, then we will take it up
On
for you.
jurisdiction point, they have already filed the affidavit.
This present one?
Yes,
Acha. They have
they
stayed.
have already filed it.
So, okay, then for hearing on Tuesday.
Yes, ma'am. Till 26.
Well, till that day.
No,
your
my
lordship will
lord.
kindly
My lord,
protect.
no, my lord.
Because we have a meeting and the hearing cannot end.
Yes.
There are so many things has to be seen.
26. ma'am.
26 on hearing day.
Yes.
And you give an undertaking that nothing will be done.
Yes, my lord. Yes, my lord.
Nothing will be done, it's okay.
But
But
I am coming to regularly court, my lord. I am assured, my lord, nothing will on 26, nothing will be done. Because they
Well, at least in that case, at least your lordship will stay this order.
no, my lord. On 6 for 6 days.
What is
Six
this
days,
submission? I
6
don't
days.
understand. Your lordship
then
putting straight
lordship-
query to him, he is unable to answer it. And at the same
My-
time, he is saying that no interim should be granted.
My lord, on 6 days, today is 20, my lord. 6 days, my lord.
I am not getting my salary. I am.
My lord, everything is
salary.
suspend going
And
on.
he is saying that I should also.
No,
not
my
be
lord, this is
getting
wrong
the,
submission, my lord.
uh,
Salary is
benefit
paid,
of
my lord.
extra
Salary is
indexation.
paid, my lord. Suspension, my lord, is not my
But
punishment.
there is a good prima facie case, my lord. That's
Suspension
why
is
I am
not
contending
punishment.
that.
okay, argue. I'll dispose it off. Argue.
My lord, I have completed my submission. Let him-
Then you argue. I'll finish this. This is not done. Yes. All other matters will get deferred. So his 2 points are, you have noted? His 2
My lord,
points are,
for jurisdiction point is concerned, my lord, I want to argue, my lord. Whether registrar in charge can issue, my lord. Registrar in charge
that to
can.
registrar in charge,
Yes, my
not a
lord.
regular registrar also.
Well, his appointment is issued by the registrar in charge, my lord. The advisement is issued by the registrar in charge, my lord. He joined it before the registrar in charge. Now says that the registrar in charge no power. When he accepted the appointment of by the registrar in charge, when joined before the registrar in charge, now the only, my lord, what previous to cost, my lord, the issuing the.
Acha, where is the pimping order? Where the memo of charges and the suspension, show me?
Yes, madam. My lord, my lord,
My lord, the memo-
my lord, he is not dismissed from service, my lord. He is only so cause, my lord. What previous cause, my lord, he appear before Department of Proceeding, my lord.
In 2411, page 74 is the memorandum of charge. And in 2422, sorry, 2412.
Oh, that is suspension. Let me take up the first matter first.
Yes, memorandum of charge is at page 70.
So that is by registrar in charge.
Yes,
Yes.
ma'am.
He is not the appointing authority.
No.
He's the issuance authority, my lord.
Issuance authority, where have you brought this concept? Appointing authority should issue the memo of charges.
So that I am trying to show one thing, my lord. His, my lord, this appointment is, it was made, my lord. Appointment was made, my lord. The appointment was made, my lord.
Appointment was made by the registrar, you have shown it.
Yes, my lord.
He was only the issuing authority.
Yes, page 234, my lord. From the Tilak Chandra Kulita register instance, Ravina so to the Sekhar so. Dear Sekhar Kanti.
Where is the appointment?
Page 234, my lord. I am glad to inform that you are selected for the appointment for the post of the Deputy Registrar Ravina Tagore on general terms and conditions to be regulated by the so-and-so, the statute, rules so-and-so, the time to time. Their term, page 35. You are,
Wait, I have not finished reading. Okay. So, this is the appointment order.
Well, this all.
I'm
terms and-
glad to inform you that you are selected
Yes, ma'am.
for appointment to the post of deputy registrar.
Yes, ma'am.
So I'm glad to inform you that you are selected. Your application and recommendation of selection committee approved by executive council.
Yes, madam.
Okay, then.
Before that, my lord, this, the what power of the registrar, my lord, they pays 237, my lord.
Yes.
Register, my lord, the register is the ex-officer secretary of the court, executive council, so and so and so, so and so. All communication in general shall be addressed to and on behalf of the university and shall be received by the registrar. Last, my lord. Next, my lord, 238A.
Then.
238A, my lord. 238 and 238A is another case, my lord. 238A, my lord, powers and duties of register, 16, and it is Roman 2, my lord. To sign and verify all appointments, contract, agreement made on behalf of the university, and to act as secretary of such other committees, so and so, so and so, so and so.
So he will sign and verify all appointments, contracts and agreements made on behalf of the university and as the, so he is not the appointing authority,
Yes,
very
ma'am.
clear.
Right. Here also this issue, it was issued, my lord, issued. Dear sir, your lordship may. Dear sir, lordship may, page, 242. This 18th executive council meeting. Page 244.
Yes.
And from 245, my lord. 244, my lord, this is the matter relates to appointment of the registrar court cases related expenses, my lord. So, my lord, from 245.
What do you want to show?
Yes, ma'am. But what does the executive council discuss regarding the allegation against the married prisoner, my lord? Dr. Sarkar submitted LM mark sheet of Karnataka State University.
Those are not required to be. This is a short campus.
All these things were discussed in executive council meeting. Executive council meeting. All these things, whatever this service was framed, and thereafter there is a resolution taken in this page 248. 248. 248. Last agenda number 7. Resolution number 7. The House expressed serious concern about the misconduct and forced activities of Dr. Shekhar Kandi Sarkar, Deputy Registrar so-and-so Hosai. And after detailed discussion of the report submitted, Chairman, agenda number 5, whatever I already stated, the member of the executive are opinion the appointment of the Shekhar Kandi Sarkar to the post of Deputy Registrar, which happened in the year 2023, is under question. As his LLM degree is reported to be invalid, and at the time of joining Register Romeo Thakur, he had only LLM degree as his PG degree, which is essential qualification for the post of deputy registrar. Moreover, the experience
The
certificate.
LLM degree is reported to be invalid.
Yes, ma'am.
And at the time of joining so-and-so university, he had only LLM degree. LLM degree as his PG degree.
Yes, ma'am. Master degree is
Which is essential qualification.
for the post of deputy registrar. Moreover.
What is this language? You are saying LLM degree is invalid.
Yes, ma'am.
And then you say that when he joined.
Then on that particular time, only he shows his LLM degrees, their master degrees, post degree. This want to reflect, my lord.
No, whatever. Then the same LLM degree, you are saying it to be invalid, right?
Yes, my lord.
Then
which is essential colon for the post of deputy. Moreover, the experience certificate from the Mahapurush Srimanda Sankadev University submitted by Dr. Sarkar, based on which his qualification to the post of deputy was considered in 2023 at Rabindranath Tagore University.
Is also fake.
Fact. Also, a PhD degree from Assam University based on LLM degree in distance mode from Karnataka Open University is also under question. Therefore, House University resolved to appropriate legal steps should be taken against Dr. Shekhar Kranti Sarkar, Deputy Registrar, taking a legal opinion so and so issue notice, so cause initiating department proceeding, etc. as per law. Executive Council authorized the Vice Chancellor to take all appropriate steps permitted by law in this regard as chairman of the Executive Council as to maintain the sanctity of the university.
So Executive Council has authorized the Vice Chancellor.
Well, already Vice Chancellor authorized the person, because Executive Council is the appointing authority. Appointing authority is not this approved, this whatever selection, it is approved by the Executive Committee. So Executive Council discussing all facts, my lord. Now only particular this somebody has to carry out this this work, my lord. So as chairman, Vice Chancellor is authorized to do all these things. Thereafter, this page 254. Here, my learned friend, senior friend already read my lord. House and last paragraph. House unanimously resolved the inquiry into the matter should continue by putting Dr. So-and-so under suspension. As the department proceeding is contemplated, strictly in accordance with the provision of Assam Civil Service so-and-so, maintaining transparency, neutrality, and due procedure compliance at this. The registrar says is authorized to issue all communication in consultation of Vice Chancellor, including the issuance of suspension order and memorandum, etc. Thereafter, page 255. This is from the Vice Chancellor.
Vice Chancellor has approved.
Yes, ma'am. The suspension order is approved by Vice Chancellor. Thereafter, page 265, ma'am. 56. Memorandum suggestions has been approved on 18 March so. Therefore, you're authorized to issue memorandum charges. Issue. Only one.
Perhaps Mr. Datta, it is like, I don't know, subject to correction. Registrar was authorized only to issue the memorandum charges or the suspension.
But the memorandum of charges said that the undersigned proposes to hold a.
That may be well this.
Number one. Number two.
Because Executive Council has decided to hold up.
No, just a minute. Lordship, your Lordship will kindly see the fallacy in this. If your Lordship will kindly come to page 242.
Of their affidavit.
Of their affidavit. This is minute of the 18th Executive Council meeting held on 6th January 2026. And what they are approving? They are approving a resolution supposedly adopted on 6/2/2026. How is that possible? Page 248, your Lordship will kindly see.
This is the minute of so-and-so held on 6th of January 26.
Yes. And the resolution is mentioned 248, it is 6th of February. How is that possible?
My lord, one thing, my lord, this, so.
Let me understand first.
Yes.
6th of January and 6th of February.
And not only
All
these,
6th of February.
not only these, even the previous resolution is also dated 6th of February. And the person concerned, respondent number 4, signs it on 6th of January. On 6th of January, you hold a meeting, you approve of a resolution dated 6th of February. Well, that's why I said, well, when they do certain things in a hurry, they make a hodgepodge of everything.
My lord, it was signed on 6/1, my lord. It is typical mistake, my lord. My lord, we can produce the original record, my lord. The date, my lord, it should be 6th January.
So many times 6th of February.
Yes, my lord.
This seems to be original.
This is number, my lord, this number. If lordship says the resolution number.
And then the date?
This is number, but lordship turn, this last page, lordship turn.
I've seen 6/1.
Yes, ma'am.
But then this is 6/1 and you see all the resolutions.
Yes,
all the resolutions
yes,
6/2.
yes, my lord. That is there, my lord. See, and it is number, my lord. It is number, it is the, lordship made, it is maybe date
You bring
also.
the records, I'll see.
Yes, my lord, original record, I'll plus.
And otherwise also, my lord, as your lordship has just asked me the question, even if the EC has authorized the VC and VC in turn has authorized the registrar, where is the channelization in the statutory enactment?
That is not there.
Where is that?
This is actually registrar has not issued. The registrar has no power. But he has issued in the name of the executive council.
But this page 74 does not say so. Page 74 says that the undersigned proposes to hold a disciplinary authority, disciplinary inquiry. Meaning thereby, undersigned exercising the power of disciplinary authority proposes to hold a disciplinary inquiry.
Acha, you bring the records because here the resolution was taken, right?
Yes, ma'am.
6/2/2026.
Understand, I've already, my lord, this, I came to know, my lord, this, their error is there.
And your lordship will also kindly call for the resolution of this one.
Yes, ma'am,
This,
no doubt, no doubt.
this-
I'll produce all record, my lord.
25th of February.
What is the difference? Resolution number 3 and resolution number 7? Why? This is?
Well, I doubt that, my lord, this has been done as per the prescription. I cannot disclose, my lord, since they will file an affidavit, I cannot disclose more than this. I doubt that this has been done by following the prescription of the act.
No, not required to file an affidavit. You bring the
I'll
record.
produce record, my lord, I'll produce.
And what about agenda 3,
Which page, my lord?
page number 254?
Yes, my lord, this is, my lord, we will produce the all, my lord, all.
Where is agenda 1 and 2?
Yes, I'll produce, my lord.
This is held on 25th of February.
Yes, ma'am.
2006. Copy of resolution number 3. You bring entire record.
I'll produce, I'll produce.
And what about this 25th of February and this is 6th of January? 6th of February or January, what, I don't know what
Yes,
is the actual date.
I'll
but-
produce, ma'am.
Heard in part? Oh, heard Mr. Surajit Dutta, learned, senior counsel, assisted by Miss Idas, learned counsel for the petitioner and Mr. S.K. Medi, learned CGC.
My lord, not CGC, my lord, standing council of Rabindranath Tagore University.
Oh, standing counsel of Rabindranath Tagore University. Heard in part. In the midst of the argument, it is felt necessary that the respondent,
University, ma'am.
university should place the records in order to see the authenticity of various documents. The learned counsel is as such directed to place the record on the next date. List this matter on Monday or day after tomorrow.
My lord,
After tomorrow.
No, no, miscellaneous day, huh?
my lord, Friday I'm not here, my lord.
Or
My lord, 20,
So Tuesday,
26,
26.
26th.
man.
List this matter again on 26th.
My lord.
My lord, may kindly observe if your lordship would not dispose of the matter, at least my interim prayer will be considered on that day.
My lord, I am agree, my lord, matter should be disposed of, my lord, because.
It's all, after seeing so
yes.
many things.
Because, yes, my lord. Because if we have some, suppose the deficiency will rectify subsequently. So it should be disposed of on the pending.
Yes, you want something more?
I was only praying for an interim protection, whether sometimes it helps us in.
Huh.
in
But till
facing the
Tuesday-
situation.
Tuesday, man, whatever, lordship completely disposed.
Don't insist on filing of the reply.
No, that the court directed us, so we did.
My lord,
Only thing is that if they
only I want to only one thing, my lord. On last Saturday, my lord, my learned senior friend client filed one additional affidavit, my lord. It was out of pleading, my lord. So he knew pleading.
No,
it is there.
nothing.
If it is on law point, doesn't, you
Yes,
don't
ma'am,
have to
only
worry.
this
Nothing,
one,
it is just.
Facts are too very
Yes,
simple.
ma'am, where
Just
we
an
have-
elaboration of
where
my-
the- where the
nothing.
issuance of
Okay,
the
okay.
register
Let me
is-
take up the subsequent
yes,
notice. No, 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 no. Sir, meeting is. Yes, Mr. Mahmood?
We have a limited prayer, my lord.
Huh.
An order was passed against me, which was actually passed as the matters were not brought to the notice of the honorable court.
Acha, what happened? Here
Yeah.
no, here no.
Kindly say, I mean, not.
No, am I taking,
57.
am I taking it for disposal or you want some affidavits to be filed?
Only little so that since January 22, I am not getting salary. My skill is professionalized in 2021. And thereafter,
Mr. Bhuya, you are appearing.
so if due to the order, due to this order of the honorable court, my salary since January 22 is not paid even after provincialization.
Even
Now,
after?
Even after provincialization of my post. I served many years in the venture school. Now kindly see the order which is dated maybe since plus 55.
No, whether the services are, whether the notice are served.
My lord, the private servant number 6 has not come intentionally because copy he has received already. And again I have sent a dusty service.
So dusty service is
But
complete.
I am not against him, man. Like, I am not against him. Kindly see only for a
So
moment.
somebody has to appear for the respondent. You starting the case will not matter. Okay, here, Mr. Bhuya, nobody is there. Who should appear? Elementary education.
My prayer is not against anyone. My only prayer is this: even after provincialization, I am not getting selected because of the order of the honorable court, which was passed without perusing the necessary record. Kindly see page 57 for a moment.
Yes.
Page 57, para 8. As there are allegations against the headmaster of Novodiganta ME School that he had forwarded incorrect information, the director shall also inquire into the matter, and if it is found that the headmaster of the school had forwarded incorrect information, appropriate disciplinary action be taken against the headmaster of the school by following the due procedure of law. So for this, my salary has been stopped.
So
How
after
can
that,
you see, this order is passed page 55, can you see? This order is passed on 14/3/22. Page 55.
22, yes.
Yes. But before that, I have rectified my mistake that now also can you see page 50. Page 50. Because there are some mistakes, here is human manner. There are mistakes, so I wrote a letter to the DO, do the Honorable District Elementary Education Minister Bongaigaon, an application to correct and include the name of assistant teacher social science in place of assistant teacher of Assamese, which is done by mistake. So therefore, kindly, my prayer was that therefore my humble request to correct the said anomaly and include the name of Narayan Chandra Rai instead of Abdul Gafur. For the welfare of the institution in future, it is my humble prayer. So I wrote.
Wait, one second.
I wrote.
1 second. Then?
I wrote this letter on 30/11/19. And Honorable High Court passed order on 14/3/22, first letter. Then DO, my lord, on the basis of my letter, DO forwarded page 52, kindly see. Page 52. From A. Hussain so to the Director Elementary Education Assam, Kahalipara, proposal for inclusion of name of Sri Narayan Chandra Rai, 80 Social Science as eligible of eligible tutor of Novodiganta ME School in place of Abdul Gafur. So application that is so and so. With reference to the subject cited above, I have the honor to like to inform you that at the time of document verification of recognized ME schools proposed for provincialization, the headmaster was not submitted the name of Sri Narayan Chandra Rai as social science teacher, and accordingly his name was not proposed for provincialization as eligible tutor. It is a fact that headmaster of Novodiganta ME School now stated submission of his wrong information in that time. In this correction, the name of Sri Narayan Chandra Rai, assistant teacher science, social science, his name proposed for provincialization of his service.
No, what is the impugn order?
Impugn order
You
is
have
that-
all made those communications that you have wrongly sent.
Yeah.
And the High Court's order says that he had sent wrong information, but
I have
a disciplinary inquiry. And if it is found that he has served, so action will be taken. Then after that, what happened?
So what my lord, in 2019, I informed the matter. And High Court passed the order only in
22.
22.
Then what happened?
So this was not brought to matter. So now, due to this order, para 8 of this order, my salary is stopped.
So no disciplinary proceeding was
No,
instituted
nothing
against
is
you?
that. Because I have already confirmed, I have informed the authority. My authority is DO, and DO immediately informed the director. So now the process of under.
That
process
was
of-
before this High Court's order,
That is-
19.
Be only because of High Court order. That lordship may kindly see, my salary I am not getting, that lordship would kindly see, that pays 8 bottom. Page 8 bottom.
Your pleadings.
Yeah, the one petition, review petition. Page 8 bottom. In
This is
regard,
review
it is
petition.
only-
Oh, it's a review petition.
Yeah. In this regard, it is only to mention that.
Where? Page?
Page 8 bottom. In this regard, it is only to mention that by order dated 5/2/21, the director has provincialized his post as tutor English language. He joined in his post on 8/2/21.
Who? Petitioner.
No, petitioner, yes. Petitioner is the headmaster. So this honorable High Court may kind.
But when this order was passed, you did not place those 19 letters.
No, that was not placed. That is the problem. Am I-
Why? It was in your knowledge.
No, it was, I informed my lawyer, but my lawyer did not inform the honorable court.
But that cannot be a ground for review.
No, review.
Review only, Order 47, Rule 1 is only error apparent. And secondly, any document which was not in your knowledge.
No,
So petitioner had the knowledge.
but, my lord.
It was not given, it was given to the advocate. Advocate did not place.
My
This
lord,
cannot be the.
Let me say, my lord, I think this so technical points may not be taken into this matter.
But
because-
review, error apparent and
That
so and
is
so.
True, but nowadays the power of review has been widened. Honorable Supreme Court has come. that-
47 Rule
Yeah,
1
I
cannot be.
think the court of record, it has power to pass any order in the interest of substantial justice. Now, lordship would see,
But that is in read proceedings, not in review.
no, in review matters also. Review matters also. Review is also part of the.
But why was your salary stopped?
The salary stop for this paragraph 8, page 56.
Paragraph 8 says that as there are allegations against you
Yeah.
that he had forwarded incorrect information, the director shall also inquire into the matter. And if it is found that headmaster had in fact forwarded, appropriate disciplinary action shall be taken. So after that,
Before that, I informed. I have committed.
why don't you
mistake.
make a representation before the authorities? You made?
No, that means, my lord, that information I have already placed before the deal.
No, they have not inquired. They have not started any disciplinary proceeding. How can they stop the salary?
List of the salaries, that is no reason is shown. So my prayer is.
You
this-
file a representation before the authorities.
On that point, highlighting all this, my only prayer is this, my lord, I have committed the mistakes. And that
You are not
mistake-
Abdul Ghaffur. So why was this writ filed?
It was filed by Narayan Gundra Rai.
Oh, his name was not forwarded.
Then, my lord, I inquired the matter and found that his Narayan Gundra Rai's allegations are correct. Wrongly, his name was not forwarded. I immediately brought the
Mr.
matter.
Mishra, you are there in this matter.
Dear madam, but one thing, madam, I have not been informed that this is upgraded. Secondly, my lordship, can you see office note, madam? The affidavit has to be filed, but that has not been filed. 11/5/2000.
Lordship, nor was I informed by the petitioner that the review petitioner that it was upgraded, man. I was just informed now, man.
When was it upgraded? Morning.
They have not informed us, man.
Just now I have come seeing the notice board that-
এতিয়া কোনে কৈছিলে আপগ্ৰেড কৰিব? আপগ্ৰেড কৰিব কোনে কৈছিলে? No,
They have not informed
did
us.
this court allow?
Oh.
Subeh, morning. You should have informed him.
Even us, man, the department, they have not informed, man.
And further,
No,
my
actually,
lordship,
my lord, I am not against anyone. I am not against anyone. If Narayan Gundra Rai's name, I have already.
So he has a plain case after the, you must not have gone through, right?
One thing is there, madam. Subject to correction, madam. The names were forwarded for provincialization.
Mm.
Very good. Then, my lord, the question comes, the Dire code. When the dire code was prepared,
Dias code.
Dias code was prepared, my name was shown against the subject, social studies.
Narayan.
No, I'm the
Gafur.
Abdul Gafur. Now, when the list was sent for provincialization, it was rightly sent that my name is against the social studies. One letter was issued from my senior
Headmaster.
side manner, saying wrongly in place of my name, it should have been Narayan's name. In that case, the DLC took the view that my name should be provincialized. At that stage, Narayan came to the court, pointed out that he obtained certain interim order. Against that, I came to this court. I pointed out the fault where lies. Then the court passed the order asking the department to verify the thing and not to release salaries from both the sides. From in the initial stage, when Narayan took the stay order, the salaries of myself as well as the principal or headmaster was stopped.
Thinking that both had a collusion and
Yes, that is there. Then when I came with the petition matter, then my salary was released, but the interference of the headmaster was not there. And direction was that the director of elementary education, as the case may be, elementary education has to take a call and make an inquiry. And if the statements made is found correct, that
then they start disciplinary proceeding.
These proceedings has to be done.
So headmaster was not the party when you moved the writ petition.
Yes, headmaster was the party by name as well as by designation. He was the party. I did not move the writ petition. Narayan moved the writ petition.
But
So,
the Abdul Gafur petition is there.
Abdul Gafur is a miscase.
It's an I. It's an interlocutory application.
226 3 petition was there.
The Lordship comes to page 54 of the petition.
26 3 petition.
There only he is agreed by paragraph 8.
Yes, ma'am.
And this is by Abdul Gafur by you.
Yes. The order passed by the single judge, saying that some inquiry has to be conducted by the department.
The director has to inquire.
Yes. That is
And if it is found that he has given false information, then inquire.
Yes.
Disciplinary proceeding.
Yes, then the stand of the director has to be there, my lord.
Therefore, my lord, today since the matter has come in the orders column, my lord, since it has come in the orders column, and since he has represented
To see whether director has taken any, has conducted any inquiry.
No action is taken within today accepting withdrawal of salary. Now my.
Or whether that can be a ground
I have
for review.
rectified. I have already rectified my mistake. Much earlier than passing order by the court.
That is why that cannot be a ground for review. You had the applications. You could have produced before the learned single judge. Then this order would not have come. So where is the error apparent or documents that were not in your knowledge?
My lord, my 19 petition, 2019, which I submitted before the DO.
Was not placed before the single judge.
Yes.
That cannot be an error apparent.
But my salary is stopped.
It was not placed by you. Then court will not know. How
Yes,
can that be
yes,
an
I
error?
understand.
So this is not a ground for
The
review.
learned court has on the power of.
So what I think I should do, of
Only
course,
my prayer is this, my lord, let me get my salary.
No, my lord, that has to
Because if I get salary, what is their harm?
first thing is that the review is not made out. But for substantial justice to you, let the affidavit from the director come.
Yes, sir.
Right? Heard Mr. M.U. Mahmood, learned
A timetable
counsel
should be given.
for the petitioner, and Mr. A. Fukon, learned standing counsel for elementary education, and Mr. R. Mishra, M.K. Mishra, learned counsel for
6.
respondent number 6. Right. By the last order, it is seen that respondent number 6 has been served. Or respondent number 5, huh? Respondent number 6, that is justice service is done, but there is no representation.
No representation. That's-
But the affidavit has not filed with whether they.
No.
It is Mr. Mishra submits that he may be given some opportunity, he may be given some time to file the affidavit in the instant case. No affidavit on record,
I have filed the affidavit.
And they have filed affidavit.
but it's not in the records.
I have no idea, but I have got, I received that affidavit copy. On 24/4/26, I have got it, but
क्या
whether
वापस
it's
से क्या?
record or not, I have no idea.
और नहीं ये मैटर 4:30 लिखे बोलो बरो हाँ 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 matters might get deferred বুলি কৈছো আৰু সেই বুলি মানুহ বুজি যাব লাগিব
Actually, everybody left. That's why he said that. I also had not gone, then suddenly I got a call.
unless I say, all advocates can leave, I'll not take up any more matters, okay. But I have not said that because of the length, because something happened in between, it happens. So I said other matters might get deferred.
Perhaps some mistake.
Okay, so the affidavit is not on record. So you let the registry verify. Mr. Mishra, learned counsel for respond number 5 submits that he has filed the affidavit in opposition in the instant review petition, but the same is not found in the records. As such, Mr. Mishra is directed to verify with the registry if at all it has been, why the same is not on records. And if it is found to have been filed, the same may be put in records by the registry. You will file an affidavit.
Yes, Lord.
Mr. A. Fukon also makes a prayer that he will file an affidavit.
One web of director.
In 3 weeks. I'll file
Appearing for elementary education.
Elementary.
Final prayers are allowed.
Can be elementary.
Release this matter on when?
My lord, on that day, my lord,
On 12th of June.
on that day, I will show the power of review. Court, number one. Secondly, my salary interim prayer may be considered that.
Hey, that day I'll dispose of what interim, small matter. Okay?
Let it be
Yes, ma'am.
reflected in order, my.
That may be not reflected, my lord, because that part, my lord, we kept open, my lord.
Kept open, that is the prohibition.
You bring the judgments on
Yes,
whoever is there here
Exactly.
will dispose.
Obliged.
Yes.
Problem.
Yes, Miss, yes. Huh. Whoever is there can come up. There was a wrong understanding that the other matters will not be taken up because I was taking up a hearing matter. Acha, then.
May be listed on next Tuesday, my lord. It will take some.
Item 61.
Item 71.
71.
I've mentioned it, my lord, by
Admission matter.
admission.
Can you do it now?
I can do it, my lord, but.
Who is for the petitioner?
For the, my lord, the education department.
Elementary. Elementary.
yes.
A. Fukon was there. Are you for the petitioner?
I am for the petition.
Okay, do call Mr. Fukon. He was just here. Mr. Bhuya, call Mr. Fukon. Yes.
Here we have challenged the.
The item. 71.
Yes. Improved order. Notice.
Oh, banana. Look at your eyes.
At page 42. 41.
Wait, I hope the file is here.
Item 71. Sir, E. Begu, appears for the department. He left, my lord, because of that.
Oh.
Item may be, my lord, pick it up on some other day, my lord.
Okay.
Very much, yeah.
Here pleadings
Any
are
good?
also complete.
Huh?
Pleadings are complete, so my lord, it may come up for admission hearing.
Any my advocate book what I did. Heard Mr. S.B. Chaudhary, Mrs. S.B. Chaudhary, learned counsel for the petitioner, and Mr. A. Fukon, learned standing counsel for elementary education. On the prayer made by the learned counsels, list this matter again on Monday, 25th
Tuesday
of
will be
May.
better.
25th.
Tuesday Matters will end like
25th?
26th.
26th of May,
Tuesday.
2026. Anyone else?
Thing of 48, my lord, regarding non-payment of pension, family pension.
48.
48.
48, yes.
Also, my lord, department has to. This is a contempt matter, my lord.
Hmm.
Same, my lord, Mr. Sharma, Sharma appears, my lord, Mr. 60. Okay. 48. What is contempt matter now?
48.
48 madam.
No, Madam, Miss Nitushri Fukan appears, madam. She also left, madam. She's the
Left. You do it. I mean, I did not say that other matters I did not take in. I'm not taking up.
Then I have to take the second.
This for nothing, people have left.
My lord, actually, the court masters informed.
क्यों को बोलेंगे?
Because the court masters informed, they all left, that's why. Most of them. I was there because I was in court 23, madam.
My God. Huh? Assumptions, huh? Normally I say that no, others can leave. I'll not take up.
Some misunderstanding.
This course times is wasted. B. Talukdar learned education. Why this pension proposal was not forwarded?
Well, Mr. B. Talukdar's name may be reflected. He was there in the last occasion.
Third, Mr. D. Gogoi, learned counsel for the petitioner, and Mr. A. Fukon, learned counsel on behalf of Mr. B. Talukdar, standing counsel for elementary education. As prayed for by the learned counsels, list this matter on when? Otherwise, you are ready with the matter, right?
I'm ready, but there is touch on this week.
I'll fix it on Monday or Tuesday. I'll
List
inform
this
you.
matter on Monday. There will be so many matters.
Then Tuesday or Thursday.
List this matter on 29th of May.
I'll inform him, madam. Apologies, madam.
I'll have to go. Yes, you have some prayer?
Item number 74, Subli Lordship. We already heard.
74.
Yes, sir. There
What
is
happened?
PTC matter, my lord. I am appearing for the petitioner here. My lord.
This one I have disposed of.
Yeah,
What happened?
yeah, already. You don't know about the disposal of this man, Doctor, senior advocate, Dr. BP want to submit more. That's why he asked me to surprise you to.
It is disposed of. Order was dictated. Petition is disposed of.
I thought that CAB was.
No, what CAV? I have dictated it for an hour or so.
Last part was not madam, completed. That's why.
Last part disposed of.
Okay, so I'm.
Disposed of.
Okay. Okay.
Yes. Okay. আজিবা নকৰিব দেই এইটো আৰু।